Yes, the matter has been listed only for
Yes, please.
fixing a date.
Fixing a
My
date,
lord.
lordships. Item one, my lords.
Item two.
Two, sir.
Item 2, the matter has been remanded back by Supreme Court. Who is appearing in 2?
Mr. Kanungo is appearing. Mr. Kanungo
Is there and Mr. Kanungo is.
In the item two has
Mr.
been recorded.
Kanungo, you are there.
Yes.
Item 2, you are there.
Yes.
Mr. Subhadata Rautra is also
I
there.
am the first matter, Your Lordship.
I am in the second matter.
No, in this
Ah,
second matter has been called only for the purpose of
Yes.
fixing a final date
Mal.
of
Your
the,
Lordship,
because
fix a
of
date.
the direction by Supreme Court. So
It's a date and if possible, your lordship fix at 2 o'clock so that it can be
can be done.
possibly.
When?
Any day after vacation. First.
19,
19.
My lord, I am away till 24th.
24th, all
Yes.
right, 25th,
25th. Great.
26th.
Whatever, 25th,
Great.
26th, whatever.
Any date, subject to your lordship's convenience.
With the consent of the parties. Let the matter be listed for final hearing on 26/6/2024.
My lord.
In the light of the it is to be kept in mind by the parties that the Supreme Court by an order dated 15/7/2019 had requested this court to decide the matter, on remand, preferably expeditiously.
Lord, I have a small request. My lord. Can I file an update affidavit so that it might help your lordship to decide?
Yes,
Both the parties can have.
Yes.
please,
Great.
great short, and please tell us what is the short point involved.
Yes, certainly.
All right, so very long point, we don't know, but
No,
No, it's a very short
It's a
point.
very short.
Very short.
yes.
Obliged.
But
2 o'clock, my lords.
2 o'clock.
Yes, my lords. Obliged.
Item number 1,
May please allow.
my lord. In this case, my lord,
I'm on virtual mode.
my lord,
Sub item.
Item number 2, sub-item. So other set of lawyers are appearing. They are perhaps not.
All right.
Item number 1 on your lordship's list today, no? But I apologize that I'm on virtual mode. I represent the OP number 5 in the matter.
Just a minute,
item 1,
just,
my lord. In
yes.
this case, my lord,
I represent OP number 5 in this matter.
Please wait, Mr.
wait,
Counsel,
wait.
let us hear the.
But my counter is
Who are
not.
you?
I am the
I'm
petitioner.
on number 5.
Huh?
I am the petitioner.
And you have filed PIL.
I have filed the PIL for the interest of the villager Kopri Kochar.
How many villagers?
One village, villagers are at 160.
160.
My lord.
So they should have approached the court
My
for
lord,
their individual interest. They want compensation.
I am not, as regard to compensation, I am nothing to say, but it has not been implemented. Our policy, right to fair compensation and transparency of land acquisition and Rehabilitation Settlement Act 2013 has not.
Who will be benefited?
All will be benefited, but
Villagers, let the villagers come. Why PIL?
villagers, my lord, all the villagers are poor, belonging to.
We shall ensure their welfare. Even if this PIL is not there, we will direct the legal service authority to look into that.
My lord, matter may be at least inquire into.
We intend to impose cost in such matters. Compensation, what are you?
My lord, I am not the. We have formed the villagers formed a committee.
Let the
Height of
villagers
their
come.
cost,
They will be getting their
right and
compensation.
my lord.
The
On last occasion, our lordship had directed that.
we had made our observations clear on the last day.
Oblige.
Are you registered?
Not registered.
No, it's not a register.
Not registered.
This writ petition in the nature of public interest litigation has been filed by Khapuri Kachar, Gaon Ganaria,
Ganarajya,
Ganarajya,
Grama Sabha Committee,
Gram Sabha,
Grama Sabha Committee.
Gram Sabha, Rajya Gram Sabha Committee. Stop. By the said committee is not registered. Not a registered body. Stop. They have raised the petitioner has raised a grievance that what is that R&R policy?
Rehabilitation and resettlement.
This act.
Under this act, rehabilitation and resettlement policy has been formulated by the government.
Where is the policy? Policy.
You are claiming right under a policy formulated under this act.
Yes.
Where is that policy?
This is the policy. New enacted.
No, he is saying that he is entitled to benefit under this act,
Under this
2013 act.
No policy.
No policy. He is entitled.
Exemplary cost.
This is individual claim. This is purely individual
Exemplary
claim.
cost in such matters.
My lord, several correspondence has been made. They have also accepted our claim. Kindly have it.
And there is a R&R court also. Your lordship may
It
kindly
is the
see.
petitioner's
There is a
grievance
court.
And belong
that
to
the
scheduled tribe community.
Huh?
All the 70% of the villagers are belonging to scheduled tribe community.
all right, they can come. We can.
Might.
There is a court.
There is a court established by your lordship. District judge is presiding over that
No.
court to adjudicate all these dispute under this R&R. Who are benefit if there is inadequate payment of compensation. Everything is. There are 3 courts in all over the state.
The provisions
Cuttack,
of
Sambalpur and Berhampur.
statutory provisions under the right to fair compensation and transparency in land acquisition, rehabilitation and Statutory Settlement Act, 2013 is not being duly implemented in respect of the villagers of the which village?
Khapuri Kachar.
Huh?
Khapuri Kachar.
Khapuri Kachar.
Kapri
Kachar.
Full stop. In response to a query as to why the individual claims of the villagers is being raised by a committee which is not registered society under public interest litigation. Learned counsel appearing on behalf of the petitioner has submitted that the villagers are poor and they don't have the resources to approach appropriate forum for in respect of their individual claims. Stop. Next, this application in the nature of public interest litigation, which relates to payment of compensation to individuals under the Act, is thoroughly misconceived and is accordingly dismissed. Stop. The villagers shall be at liberty, the individual shall be at liberty to approach. They have to approach whom?
That is Land Acquisition, Rehabilitation and Resettlement Authority, LARA code, that is called.
Lara Court. Appropriate
Achha.
Lara Court. Stop. Next, we further observe, which district is this?
Culture.
Pardon?
This is
Culture.
this is Sundargarh.
Talcher is,
This is
will be under
Sundargarh.
Sambalpur
Sambalpur.
division.
Apurikottar ko district?
Sundargarh.
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 Using the present
Sundargarh.
Say Sambalpur.
Sambalpur,
It is
it's all under Sambalpur division.
that let the Secretary District Legal Service Authority look into the genuine grievances of the villagers,
Individual, your lordship may say individual.
of the individuals in this regard. And if it is found that they need any kind of legal aid, the same be provided to them by the legal service, district legal service authority. Let a copy of this order be communicated to the Secretary District Legal Service Authority forthwith. Sambalpur forthwith. Yes,
Yeah.
never do this. This
Yeah.
time we have not imposed cost. We would have imposed exemplary cost. We understand. Number 5.
I am also appealing for.
Aditya Narayan Das. Aditya Narayan Das, OP number.
Please send your appearance. Please give appearance.
Keep your life.
Item number 3.
Item number 3, considering the nature of the dispute, your lordship on the last occasion by order dated 2/5/2024 was pleased to direct the parties to settle amongst themselves, because more or less your lordship appreciated that it is a family dispute. Originally, the dispute arose when the leave was granted in favor of the late father of the present appellant.
So it could not be resolved.
My lord,
No,
in fact,
that could not.
I am appearing for the mother. My lord, I had talked to my senior also with regard to the settlement. The proposal was that we will maintain the mother, so you partition this property. I passed on that message to the mother also. Mother is not accepting such a proposal because mother says that she was harassed enough, so she doesn't feel secure. One more interesting aspect I beg to point out, this son writes a 2-page English notice letter to the mother saying that come forward for settlement. I hope my senior appearing for the son appellant will produce that. I have not been able to make copies. Your lordship will see this is the way the son wants settlement, which possibly cannot be carried out. So on merit of the appeal, I have to assist your lordship, and obviously the appellant has to assist your lordship as to whether the order of the honorable single judge is sustainable or not. But in the meanwhile, I have collected some documents from the RTA office under RTA Act, which I just want to place it before your lordship for consideration. But that is relating to that original allotment in favor of the husband of the present respondent or father of the present appellant also. So that needs to be looked into for the purpose of consideration. So I pray your lordship may fix a date for hearing. My lord, I'll assist your lordship. Because resolvement I find may not be possible when the son writes a 2-page notice kind of thing to the mother that you come forward for a settlement. He could have very well called the mother or would have written how it is written to a mother, not a notice.
Yes, we will decide.
If you want, your lordship may fix a date because I have got materials. I will assist your lordship on the legal aspect of it.
Legal aspect is there, we will decide on this.
My lord, I pray, my lord, your lordship may kindly give me some time.
Why?
My lord, I have done homework, but I need the time for your lordship's kind consideration. I am praying, my lord.
And requested on behalf of the. Yes, we are granting time. In the meanwhile, please further make.
We will make efforts. We had written, in
Please
fact,
do
to
it.
our mother, the appellant had written to respond number 1. There is no positive response.
But you are writing in English. Why are you doing it?
I'm sorry.
You
I will ask him to go personally and
Go
make.
personally, touch her feet, seek her blessings. This is how the family disputes are
That
brought.
he has, I have been instructed that he has been seeking long since, not now, of both the parents. Now, after the death of the father, this has been, if your lordship permits, I will submit that due to the intervention of a third party having vested interest, this dispute is cropping up.
Maybe. Still. Should we refer the matter for mediation?
As your lordship was pleased to observe, if your lordship gives a breathing time, let him go and meet the mother. I think I will ensure
do
that that will happen.
Please do.
So your lordship
Yes.
may post it after the vacation, and I'll
Such
definitely
dispute,
from my side I will ensure it, my
I requested on behalf of. Respond number?
one.
Respond number 1. This matter on 26 June.
My
Yeah, your lordship. There is an interim order to which your lordships were pleased.
Interim order shall continue in the.
May I submit one thing? Since the appellant apprehends that there may be some difficulty on his part, your lordship may observe that it is open for the petitioner to inform the local police.
who needs to meet the
Who
mother,
stops?
my lord? I am there for the respondent number 1. I think I will exercise my good office. Will it be required? Police help to meet the mother, my lord?
No, not to meet the mother.
I can give this
But
statement
to
in court,
prevent
my
the
lord.
apprehensions,
My
because
lord,
the
that will
third
never-
party
nothing will
interest,
happen.
the third party interest is involved.
Yes.
Obliged.
Item number 4.
Yes.
No, see, 2020 contempt. Also, I don't have any instruction because I have not sought for an instruction. The petitioner is not also there now. I think there was a direction for taking or disposing of the representation, and I had obtained
There
it.
is
It has been disposed of.
There is no representation on behalf of the petitioners. The petitioner has alleged disobedience of this court's order dated 6/3/2018. 6/3/2018. Whereby the contemptor Tahsildar Dharamsala was directed to dispose of the petitioner's representation. Top. Land Council appearing on behalf of Land AGA for the contemptors has submitted that the said representation has been disposed of. Top. The contempt proceeding is accordingly dropped.
Item number 5.
My lords, we already received the payment, my lords, for instruction.
Complied with.
My lords.
Complied with.
Receive.
Item 6.
Item 6, my lord, I think for the petitioner, lordship, I don't have any, keep it after vacation so that I'll take. Petitioner the land house tree under the lower Suktal irrigation project. He was paid some compensation, same was received under protest.
So what is the order? Let us see.
My lord, page 10, para 2, the operative. And the enhanced compensation was sent to the government for according approval. That was pending. The government was directed to accord approval so that LU can disburse the same. That was the order. Page 10, para 2. Though whether it is complied with or not, I don't have any instruction. That is
But
why.
you should have told us.
My lord?
You should have told us. Whether
No, in fact, this morning I got the list, tried to contact the party, I could not.
tomorrow we'll take up.
As yours.
Inquire.
Yes, yes.
Item 7.
But the short point here is, in the garb of compliance of the this honorable court's judgment and order of the honorable Supreme Court, they have taken away the benefit seniority which they have given us in terms of the judgment. That's the short point.
So you can challenge. This is what the Supreme Court says.
So, my lord, may I just, of course, my lord, this honorable court in the judgment clearly said that all consequential seniority and benefits shall be granted. Lord, matter went to the honorable apex court. My lord, honorable apex court also said in the same line, except modifying the dates of benefit, my lord, except modifying the dates of benefit. Now, in terms of that, kindly see one document, my lord. They have allowed in my favor. My lord, see.
Now, whether there are two aspects.
Right, my lord.
One, that the matter had gone to Supreme Court.
Right, my lord.
And the Supreme Court modified the order.
So great.
So this order merged with the order of
Honorable
the
Supreme Court.
And the contempt would lie there.
Yeah, Lord. I was also of the same view. I told the client today morning that either you have to approach. In fact, we had approached the Honorable Supreme Court. I must bring it to my lord's notice. Honorable Supreme Court, I would not have troubled my lord's. Honorable Supreme Court said that go and approach the High Court.
Contempt jurisdiction.
Yes, kindly see, my lord. Yes. That's the problem with me, my lord. Otherwise,
High Court by filing a writ petition.
No, they say,
that order.
Lord, in fact, I must bring it to my lord's notice.
Yes.
Appropriate application to ventilate their grievance. Not page 67.
Ventilate their grievance.
It is now it is a subject to interpretation as my lords interpret this, my lord. But then kindly see, it's a small issue. It's a very small issue.
We cannot enter into that suit.
Lord, may I be granted that liberty, Lord?
Learned counsel for the petitioner after some arguments. Senior counsel appearing on behalf of the petitioner after some argument seeks permission to withdraw this contempt application with a liberty to question the correctness of which order?
The order dated 24, Lord, that is order dated 24/12/2021.
24/12/2021 before appropriate forum in accordance with contempt proceeding stands strong.
Liberty be granted.
That liberty is there.
So grateful.
Both the cases.
Both the cases.
Both the
Right,
cases.
both the cases.
Item number 8.
May I please, your lords? After the death of the appellant, the legal rights has been substituted by your lordship's order.
Where is the order?
My lord,
All right. Where is the order?
the substitution order. My lord, after the death of the appellant, legal heir has already been substituted. The sole question in this case is the deceased employee before appointment has acquired MPhil degree and after appointment has acquired PhD degree. The Honorable Supreme Court in Mamata Mahathi case has held that lecturers with MPhil or MPhil, either MPhil or PhD degree is entitled UG scale of pay. And in Mamata Mahathi case, Honorable Supreme Court directed the state government to examine each individual case and extend benefit of UG scale of pay those who have acquired either MPhil or PhD degree. On the basis of said judgment, the state government implemented and extended all the lecturers having PhD MPhil degree. In the instant case, before appointment, the deceased employee had MPhil degree and after appointment had acquired PhD degree, both degrees. And as per government resolution Annex 6 and 7, clearly stipulated that UG scale will be given to the lecturers having MPhil and PhD degree. And Honorable Single Judge, to due respect, did not consider the said aspect and passed the impugned order. And last occasion when your lordship going to admit the matter, the learned AGA submitted the order of Alok Mishra saying that matter is sub judice before the Honorable Supreme Court. My lord, in Alok Mishra case, he has neither MPhil degree nor PhD degree. He was appointed in 99, where the deceased employee is appointed in 86, before the college became added, and he was appointed after the college became added, and after the cut-off date, that is 1/4/89. The deceased employee was appointed before the 1/4/89 cut-off date. Your Lordship's last order, dated 26/4/2024, kindly see, Your Lordship mentioned that it is not dispute that appellant's case in the present appeal depends upon the outcome of the SLP pending before the Supreme Court. My case is directly covered with the Mamata Mahathi case because and first post and third post having extended UG scale of a petitioner, this is an employee was holding second post and disability, 50% permanent disability, denied UG scale of pay. Therefore, I filed petition IA, my lord, that to either modify or recall the order so far as order dated, your lordship's order dated.
How can now we had recorded that it is not
Dispute.
in dispute that the appellant's case is in present appeal depends on outcome. So how can we?
My lord, my case is different footing because that Alok Mishra did not have either PhD or MPhil.
File an affidavit.
I am filed affidavit and I have also filed, that is flag, my lord. Flag C to my IA.
Yes.
May I clarify on only a batch of appeals are pending before the Honorable Apex Court, including Alok Mishra. In those cases, dispute relates to twofold. I am clarifying in 1 minute, my lord. Dispute relating to that UGC in 2-3 manners, my lord. In some cases, those who have are not eligible as on the cut. There is a cut-off date that is 1/4/89. Those colleges are eligible to receive dentinate as on the cut-off date for the post have been approved subsequently. 3 types of cases, and all the cases, including Alok Mishra, are tagged up and now under sub judice before the Honorable Apex Court.
Why are you making this submission?
And it is not the only Alok Mishra case.
Why are you making this submission?
I will also say a batch of.
I have given the judgment of the Honorable Apex Court in Mamata Mahathi case. So, Lordship, kindly, I may kindly be permitted to place that.
No, but that matter is pending before Supreme Court.
A batch, my lord. I am giving my number, my lord.
My humble submission is different footing. Neither Alok Mishra have a MPhil PhD degree nor appointed before 1/4/89.
PhD is not the subject matter of challenge before the Honorable. 3 categories of teachers are there. One category of teachers who were initially appointed against a +2 post, +2 college, subsequently posted to +3 college. In those cases, this Honorable Court has granted writ in their favor. That our case, that since they were appointed in +2 colleges, and as per the UGC notification of the state government, they are not covered under that. Accordingly, a batch of SLP also is pending there. If my learned friends argue that matter will be, I have no objection. Your lordship may fix any date. It can be hard on merit. I will place all the judgments.
You cannot command the court.
No, my lord. I'm just saying.
We have recorded in our order,
my lord,
that it is.
My humble submission. My humble submission, that is not different footing. Therefore, I have enclosed the Mamata Mahathi case, my lord.
We will see later.
That is judgment of the Mamata Mahathi, also Apex Court, my lord.
Awaiting decision of the Supreme Court in case of so and so. Special leave petition diary.
My lord, it also batch of around 100 matters, my lord. I am giving 30-40 matters.
This Trailokyanath Samal.
Yes.
That is enclosed to flag C.
I have given on last occasion, I have given that.
So this 6214
special leave to appeal, in bracket C number 3544 of 2020. Is this matter on 8 weeks.
Item 9.
May I please? So this matter, my lords have already condoned the delay. I took time, tried to for discussion, but ultimately, my lord, so I will be arguing this case. My lord, the judgment order 11/8/23 of the Honorable Single Judge is under challenge before my lords here. Before I take my lords to the judgment, the undisputed facts. Number one, the petitioner was appointed.
Madam, please.
The writ petitioner was appointed on contractual basis against a sanction post. Created post.
And
As peon
on
15/10/2007.
what happened?
No. My lord, ask me.
Yes, what happened thereafter?
No. Then he was regular.
Appointed where, in which?
Then he was regularized on 12/12/2013 by the collector.
Yes.
Then, I will place those. According to the rule, the notification governing the field, the regularization is to be done by the high power committee, not the collector. So the high power committee, in its meeting, decided, while deciding to regularize or not, found these are ABC discrepancies, revoked the order of regularization, asked the collector to revoke it.
When?
That was on
22/4/2014.
That was on, my lord, 25/6/2014.
It was revoked
It was revoked.
or decided to, or had asked the collector to revoke.
To ask asking the collector to revoke.
Yes.
Then the ultimate order revoking was passed on 10/1/2015. Again, the writ petitioner, the question of regulation was again discussed, taken up by the high power committee in the year 21. And again it was rejected.
No, it was never rejected. It was for the first time rejected in 2021.
Yes, sir. But high power committee was considering in 2013-14 as well.
No, 2013, the high power committee considered only on the ground that something which was required to be done by the high power committee had been done by the collector.
Actually, my lord, I will show high power committee also observed that certain deficiencies were there. That also high power committee observed. That's why I said.
Yes.
Now, my lord, the writ petitioner comes.
High power committee decision?
This is, my lord, 29/21.
No. No. That decision.
First decision.
Answer 9.
No. We want to see this. When the high power committee directed the collector to revoke the order.
My lord would like to see that.
Yes.
That my lord will see. My lord may kindly turn to page 71,
Yes.
Annex 8. Probably I have given wrong date. My lord, I said probably,
22/11/2014.
yes, ma'am, 22/11/2014. Page 71, my lord, will kindly see. This is the High Power Committee. My lord, may I kindly turn to the next page, page 72. Para 7. May I read it, ma'am?
Yes.
In case of Sri Dutya Bhoi, this is a writ petition. Collector Nuapada has gone beyond the words and spirit of GA Department resolution dated 10/1/40 to regularize his service at his level. The committee unilaterally agreed to instruct the collector to revoke such regulation order. He will be further requested to furnish details of recruitment procedure followed in case of Sri Bhoi so as to reconsider the matter, if found fit for regularization. If my lord is looking at this, then may I take my lord again, just the next page, page 73. The 29/21 High Power Committee minutes.
Yes.
My lord, page 74. My lord, the third paragraph, it has not been numbered, but dot mark, third.
Yes.
The cases of Sri Satyavan Sahu, my lord got it. Cases of Sri Satyavan Sahu, contractual peon, Rayagoda, Srimati Pramodini Amanatya, contractual peon, Nabarangpur, Sri Dutya Bhoi. Here comes the writ petition amount. Contractual peon, Nuapada, Prakash Chandra Darji, central peon, Malkangiri, Sri Krishna Chandra Sahu, contractual peon, Sambalpur, were not considered by the Committee for Regulation of their Services, as it was found that the due recruitment procedure have not been followed for their appointment. Now, my lord, as I take my lords, these are the backgrounds, man.
This is a very irresponsible decision taken in 2021.
Well,
the earlier decision was taken in 2024. There is no, there may be something, we don't know, but prima facie it appears that there was no development after 2024 or 2014. And in 2021, this decision is taking vaguely mentioning that due procedure was not followed.
Exactly, ma'am. I will point out that. Naturally, my lord, from a plain reading, it does appear as if that authority has not applied. I'll take my lords to exactly that provision why this was written so. Now, my lord, in 22, the petitioner comes, writ petitioner comes to this honorable. That my lords have the writ petition. He has approached this honorable court in WPC 17383 of 17338 of 22. And this honorable court disposed of the matter on the at the stage of fresh admission that you take into consideration in accordance with the government resolution and you take a pass an order within 2 months to observe the petition in accordance in terms of that resolution, you take a decision. Now, my lord, we, in terms of that resolution, we did find because that she was not, the conditionalities, mandatory conditionalities having not been followed, she was not covered under the 17/9/2013, so we have not done. Now here comes the next petition. My lord, may I take my lords, as I start my submission on this case, my lord, may I take my lords to the very first page 28. What was the prayer? Page 28 of my writ appeal. I have annexed the writ
petition.
That is, I have annexed, ma'am. In my writ appeal, I have annexed. So, my lord, may straight away come to page 28 of my writ appeal.
Yes.
Now, my lord, this is the prayer with which the petitioner approached, writ petitioner. Under the aforesaid facts and circumstances, it is therefore prayed that this honorable court may graciously be pleased to direct order the opposite parties to observe the petitioner since year 2013 as per, this is important, my lord, Group B, C and Group D post repeal and special provision rules 2022, and thereby quash the order dated 10/3/23 by concurrently holding the same as bad, illegal and not tenable in the eye of law. As my lord said, looking at page 28, my lord may kindly look at the top, the paragraph preceding the prayer. There also the petitioner substantially pleads that she is covered under the contractual appointment rules. Now, my lord has seen that contractual appointment rule 2013. Now, 2013 contractual rules came to be repealed in 2022. And while repealing that, under para 4, a provision is made that all those appointees under the 2013 rules will be regularized from 13 or 14 or 15. Now, here is a person who is appointed in 2007. She claims to be covered under 2013 contractual rules, under which was not applicable to her. But I am aware, well, submitting so, I am aware also that this honorable court had the power to modulate the prayer. And maybe if relief can be granted. So, my lord, I will be also addressing my lords on merit. Rightly, therefore, while disposing of the writ petition, the honorable single judge doesn't take note of this rule at all. It was not applicable to her. Now, my lord, my next submission, with this prayer, she approached this honorable court. Now, may I take my lord to page 41, please. Page 41 of my writ appeal.
Yes.
Now, on page 41 is the order 49/2007, which is the beginning of the issue. By this order, I am directed to convey sanction of the governor to the creation of 17 posts of peon on contractual basis at a consolidated salary of such and such. The charge is debitable. My lord, may kindly come below. The collector, Khurda, Nayagarh, Jagatsinghpur, Kendrapada, Jajpur, the Honorable District Bargarh, Malkangiri, Rayagad, Sambalpur manager are requested to fill up these posts of peon on contractual basis by 31/10/2007, observing all formalities and guidelines and taking a written undertaking from concerned candidates under intimation to this department for placement of her. Now, this was the creation, and after which the writ petitioner came to be appointed. Now, my lord, may kindly turn to page 43. On 16/10/2007, the writ petitioner was appointed.
Yes.
My lord has already seen that appointment order, paragraph 3 and 4.
No, you said you were appointed on 15/10/2007.
My lord, there is 16/10.
16/10.
16/10. I'm so sorry. Actually, while suddenly telling the dates, so sorry. 16/10/2007.
Yes.
Paragraph 3 and 4.
15/8 is signed. The collector signed.
Well, that will be 16.
Below his signature, 15/10 is there, but
Well,
the
later
office order was
issued on 16/10.
issued on 16/10.
So,
Yes.
that paragraph 3 and 4, that he shall not claim any regulation and he has to give an undertaking.
No.
I'm only placing that. What was the circumstances? Now, my lord, may kindly see page 45. It is the undertaking of the writ petitioner in terms of that appointment. Next, I will place, my lord, page 47. The order dated 12,
Page 44, you cannot rely.
my lord,
Page 45.
45, ma'am.
Yes.
This is the undertaking submitted by the,
Undertaking, what does he understand about this undertaking?
and that's why I said I am not going to place it. These are the, these are,
45 is in English. He
my lord, I
doesn't know.
assure this honorable court, I will not even touch this aspect.
All right.
If I am not able to satisfy my lords legally, then I will not go to this aspect. Page 47, please, ma'am. 12/12/2013. Here comes the, my lord. It is the order of regular appointment in favor of the writ petition. In pursuance to resolution, my lord, this is important. In pursuance to the resolution number such and such, dated 17/9/2013 of Government in GA Department, Para 2, the temporary appointment of Dutya Bhoi, son of such and such, District Noapada on contractual basis at a consolidated salary of 2,500 per order number, white order number 121 dated 15/10/2007 of Collector Noapada against the vacancy duly created by Government of Odisha Finance Department by the letter number such and such, and on satisfactory completion of 6 years of service on 15/10/2013, Dutya Bhoi, son of such and such, is appointed as peon regularly with effect from 16/10/2013. This is the order of regulation that has been passed by the collector. Thereafter, my lord, may kindly come to page 48. This is 25/6/2014. This is from the government. May I place it, ma'am?
Yes.
In inviting a reference to your memo number 68/12/12/13, which my lord I just now read, on the subject noted above, I am directed to say that you have regularized the service of Sri Dutya Bhoi, contractual peon of the small savings section of your collectorate without approval of Finance Department. It seems the procedure indicated in para 3 of GA Department Resolution number 26108 dated 17/9/13 on mandatory eligibility conditions on regularization of contractual group C and D employees have not been followed. I therefore request you to intimate whether the mandatory eligibility conditionalities prescribed by the GA Department have been followed with regard to the regularization of service of Sri Dutya Bhoi for further action at this end.
Yes.
Then, my lord, to this, the collector responds. My lord, may kindly turn over the next page, page 49. Now, how the collector responds, ma'am? My lord, may kindly see. Para 1, inviting the letter, the response is 1, 2, 3. 1, regular appointment. As it was the single sanctioned post of peon in District Small Saving Office, Noapada, there is no scope for preparation of gradation list of contractual employees by the appointing authority. Regular appointment of the aforesaid contractual employee has been made on completion of 6 years of service by this office order number 66 dated 12/12/13, as he has been initially appointed on contractual basis by this office order number such and such dated 16/10/2007. After completion of 6 years of contractual service. So this is the response, my lord, the collector has given. Now, my lord, this is the factual scenario. So, my lord, what is essential? That is coming up, according to me, my lord, I'll be submitting whether the writ petitioner was fulfilling two conditions. 17/9/13 resolution, whether that resolution of the government, whether if she was fulfilling the criteria, then she has a case, ma'am. She is bound to be regularized. Now, let me place 17/9/2013 for my lord's appreciation. 17/9/2013, my lord will get at page 61 of my writ appeal, ma'am. This is, my lord, may kindly see page 61. regular appointment of existing contractual Group C and Group D employees who are not holding any post in contravention of any statutory recruitment rules made under the proviso to Article 309 of the Constitution of India or in executive instruction in absence of such rules. The policy regarding regular appointment of following categories of contractual Group C and Group D employees appointed under the state government was under active consideration of government for some time past. Contractual appointments, engagements made against contractual posts created with the concurrence of the Finance Department on abolition of the corresponding regular post or contractual appointments, engagements made against contractual posts created with the concurrence of Finance Department without abolition of any corresponding regular post in case of new offices or for strengthening of the existing office services following the recruitment procedure prescribed for the corresponding regular post and the principle of reservation of post and service for different categories of persons decided by the state government from time to time. Government, after careful consideration in supersession of the resolutions, orders, instructions issued by different departments of government to that effect, except as respects things done or omitted to be done before such supersession, have been pleased to decide as follows. Regular appointment, then a gradation list of such contractual employees shall be prepared by the appointing authority on the basis of their date of appointment. In case the date of appointment of two or more employees are the same, the interposition may be decided on the basis of their date of birth. Regular appointment of the above categories of contractual employees shall be made on the date of completion of 6 years of service. This is the provider. So it says, 17/9/2013 says, the mode of regulation of contractual employees on certain conditions.
What are those conditions?
Exactly. That is my next. That is 65. My lord, may kindly come to page 65.
Yes.
That gives the answer, my lord, to that is my answer to my lord's query.
Yes.
Page 65. That is resolution dated 16/1/2014.
By then he was already.
Said how 2014 will apply in case of that 2000, this decision was taken in 2013, 17 September 2013. Regular appointment.
Even if 17/9, let me place 16/1/14, then I will answer my lord's query as to how these, if how he can say that he is not covered. See, you will be covered, man. Even 17/9/2013, my lord, does speak of the very same things. Only 16/1/2014 gives out the mandatory conditionalities as to how it is to be worked out. That's all, my lord. It doesn't say anything beyond 17/9/2013. May I place, my lord, that 16/1/2014 at page 65.
Yes.
Regular appointment of existing contractual Group C and Group D employees who are not holding any post in contravention of any statutory recruitment. Same thing, ma'am, as written there. Proviso of the Constitution of India or any executive instruction in absence of such rules. As per General Administration Department resolution dated the 17/9/2013, the following are the mandatory eligibility conditionalities for regulation of contractual appointments engagements. Contractual appointment engagement must have been made against a contractual post created with the concurrence of the Finance Department on abolition of the corresponding regular post or contractual post created. My lord, this meets. Then 2, such contractual appointment engagements must have been made following the recruitment procedure prescribed for the corresponding regular posts. Then 3, principle of reservation of post must have been followed in case of such contractual appointments. Then, my lords, it is not automatic. Question is, then comes a high power committee. The high power committee, by this resolution, the high power committee comes into being to decide anything on regularization. If now there is a question, my lord, post me 17/9/2013, 16/1/2014 had not come. Well, 17/9/2013 having not laid down the mandatory conditionalities to be followed, she could not have been regularized. That will be my only answer to this honorable court. Because 17/9/2013's mandatory conditionalities to be followed to regularize, having been prescribed in 16(1)(14), she could not have been regularized and much less to speak of, my lord, by the
Whether
order
the
of collector.
whether the collector is the appointing authority of that post or not.
Pure, yes, my lord, collector is the appointing.
He is the appointing authority. He took a decision to regularize.
Well.
Following the policy framed in 2013.
My lord.
He did not follow reservation policy. He did not follow many of the procedure which were to be prescribed as regards conditions, recruitment, everything. Have you dismissed him? And what have you done? Because he is a PN, you have taken action. And he is collector. Now he must be the secretary of a department. You will not do anything against him. So even if we come to this conclusion that this was required to be followed, we will not disturb this, the court's decision, the single judge's order.
No, and
Because just see the condition that this PN is fighting litigation since when?
22, man.
Not for her fault. She must not have applied for regularization. She had worked for 6 years and thereafter a competent authority who had the authority to appoint to that post, he decided to regularize.
Yes, ma'am.
That was technically incorrect according to you. He was not incorrect on the date when he had regularized because you did not have that condition. You were yet to lay down the condition. So was there any condition that till this the conditions are laid down, no regularization shall be met in 2013?
May I answer that? Two things. My lord has seen only 2 documents also. I am not trying to substantiate any wrongdoing of any collector. My lord has already seen 2 documents. 14,
No, we will do that.
My lord,
We will say how the state has fought this litigation against a PN in what circumstance. We will record that.
my lord, only 2 summations.
Yes,
I am just trying to do my.
we have a duty to deal with each and every
So grateful.
aspect which is argued.
So grateful.
We can go to the extent of saying that you may be legally correct, but we decline to interfere.
I will say only 2 documents.
Yes.
My lord has already seen 14/9/2007. The document, very document creating those posts. It clearly mandates, my lord, if not anything else, it clearly requires the collector to follow the recruitment.
Therefore, you should have initiated action against him. Both of them should have been out from job. PN and the collector both. If the misconduct was of such nature that you decided to take back the livelihood of an employee of the level of PN, then at least the district magistrate should have been removed. And just think of this regularization in 2013, you take a decision to remove in 2014, and then in 2021 you consider her case.
My lord, because she is continuing. My lord, I was asking that question. My lord, I was satisfied with that answer. Maybe I was asking that if in 2014 we rejected, how did that she was continuing? Then the answer was we instead of throwing her out, she was getting some. She was in contractual appointment. My lord,
She was.
my lord,
What are you
actually
talking?
there is no.
She was.
My lord, this was the.
You were merciful.
My lord,
to.
I will not exactly say that. But
Model employer.
my lord, I will not.
Model
say,
employer
I will not say that,
exploiting
I will only say, my lord, we have not thrown her out.
exploiting group D. Peon.
What I was hinting at. In 2014, at least, my lord, in 2014, the petitioner knew that there was no recruitment.
The petitioner is a PN.
But
you take her undertaking on a paper which is written in English.
no, that is submitted by her.
What submitted by her?
That undertaking is submitted.
You have
I have
now
not written it.
Your undertaking does not contain a certificate saying that this was read over and explained to her in Odia.
Just see the undertaking.
Well,
You are obtaining her signature on this thing, English document.
she signed in
But it
Odia.
is not that we dictated and she signed. See, we wanted this undertaking in
Was
terms
she
of the
aware of
appointment. So-
what she is signing? Was she aware? What is the content?
No, I'm not, I only sold that document, but I have not argued that document. Now, question is, as I was pointing out, two documents. One, 2007 required the collector to, that has not been made. And two, my lord, that in at least 2014, when we rejected that case, and even at that point of time, had there been a recruitment, she would have, but maybe, my lord, that would have been considered, my lord. But thing is, we were not at fault to decline the regularization because we had to follow strictly the 79
So you could have
2013.
done that in 2015.
My lord, 79 2013 itself also doesn't, it doesn't, by 79 2013, the
No,
recruit itself doesn't have any
The
eligibility.
High Power Committee took a decision in 2014.
My lord.
It could have taken a decision not to regularize the services of this of the writ petitioner. So where was the occasion for the High Powered Committee to take a decision in 2021? Why?
Because, my lord, in 14, collector's order of regularization comes to our notice.
Exactly. Therefore, in 2014, you could have reconsidered whether they are to be regularized or not. This High Powered Committee, the action should be taken against the members of the High Powered Committee. What kind of High Powered Committee is this? We shall record. This is it is good that these aspects have been.
My lord, on that only two things, my lord, subject to my lord's acceptance. High Power Committee was not aware of if any recruitment procedure was followed. Or may I read that, my lord, again? Actually, High Power Committee said what? May I read that, my lord, again? High Power Committee only said in 2014, the committee unilaterally agreed to instruct the collector to revoke such regulation. He will be further requested to furnish the details of the recruitment procedure. So, High Power Committee wanted to examine, my lord. It's
So
not
the
that
collector responded to that
in 2020, man.
in 2020, and again the collector in service.
And but in 20,
In
so
20, the collector
Hello.
responded, and all the collectors in the meantime who were their collector of the district, they are continuing in service. And this PN is out.
No, he was also working.
No, but now he is out.
Oh my lord. After 1/3/23. So in 21, we considered, we found that these are deficiencies. We cannot be. We have done, my lord. I have, because these minutes I have given.
We have also some duty to do. Some
Well,
duty to discharge. Judgment reserve. Just.
I've solved my running friend, but because I couldn't, affidavit is only saying that after February 2023, she is not in service anymore. Only to that much, bringing that much fact to my lord's notice. An affidavit has been, I have prepared an affidavit, I have served copy. May I give it, my lord? Because today.
When was the order passed?
Just one.
Just a minute. When was the order of the London Civil Judge passed?
That was on 11/8/23.
11/8/20.
Yes, she was not in service from March 23.
Therefore, she had, huh?
Yes.
Well, that's when they have rejected the regularization, they've stated the word regretted. Your continuance is regretted when there is a stay order from this honorable court. I have challenged the earlier rejection of my regularization. Then they have filed a vacation of stay. Well, by the time of filing vacation of stay, Honorable Single Judge said, when you have filed an application for vacations of stay, how can you pass such an order? Your continuance is regretted. That's why, my lord, the final order has passed. Obviously.
Item number 10, my lords, on behalf of the conducting council, he is met with some injuries due to an accident. My lords?
What has happened to him?
My lords, bike accident, he fell down.
Hey,
No, my lords, last week.
you are.
My lords, after vacation, any day. I may pardon my lords.
Item 11.
Deeply authorized.
Item number 11.
Yes. State.
Item 12.
May I please, your lordship? May I please, your lordship? Taking for adjournment. Item number 12.
When do you want?
After vacation or any date, my lordship.
Item 13.
Oblige.
You better by said that the council for the petition act number 11 is died in the meantime. That is
Oh, but even then, that, then we can what is the prayer meant? Because the prayer cannot be interpreted. Prayer cannot be interpreted.
Item 13.
Item 13, lordship, I pray after vacation, lordship. Item 13, lordship. I pray, lordship, after vacation, lordship. 13, 14. 14, lordship, same, lordship.
Item 15.
Order dated so and so. Passed the
Item number 15.
Item 15, my lord, I am appearing through VC, my lord. I am for the appellant. The present writ appeal is directed against the order of the Lord and Single Judge. At page page 21, straight away, I would like to draw your lordship's kind attention. This matter relates to an insurance claim under a health insurance policy, Miller. I was the opposite party before the Lord and Single Judge, and I have taken several grounds like that alternative remedies are available, and disputed question of facts involved in the case. However, without entering into the merit of the case, the Lord and Single Judge directed as follows, Miller. Page 21 of the brief.
You are the insurance company.
Sir, I'm unable to hear. Your lordship is not audible, Miller.
You are the insurance company.
Sir. Yes.
The direction is just.
Yes, direction at page 7, at page 21 of the brief, para 7, Miller.
Yes.
Very small, short point, Miller, involved in this appeal.
Yes.
Para 7. Considering the submissions and after perusing all materials of record, the petitioner is directed, who is the respondent before my lord now? the petitioner is directed to approach the opposite party insurance company along with all the medical documents, and the opposite party insurance company shall verify the insurance claim and pay the insurance amount as claimed by the present petitioner within a period of such and such. Here, Miller, the last line of the order that when the Lord and Single has directed the insurance company to verify the documents and at the same time directed to pay the amount claimed for by the. So that is my grievance, sir. It is like a direction to give to dispose of the representation and
It's on the other side.
Sir,
You have to issue notice.
not appear. This is first time.
Notice.
Lord, I prayed stay of the impugned order.
Let notice go. Let them come. No.
Item 16.
Obliged.
16, my lord, this writ appeals related to the medicine shop matters.
Give this. No. How many?
It's all the sub.
Huh?
All the items in.
How many shops are there?
So far as.
100 shops are there in Odisha, Your Lordship.
No, no, in this matter.
In this.
In this 100. How many such shops are there?
All medical colleges, PSCs, PSCs, there is a medical shop.
Total, there are 146 shops in Odisha. 146.
So you can have your medical shops outside the college.
She was kept it on 3rd of July for final decision, Lordship.
All right.
Item number 17.
Grateful.
Item 17. Your Lordship will recall this matter was taken up yesterday. Your Lordship had posted it for orders today. This is regarding that whether the director.
We will pass order on Monday.
Monday.
Because while going through the brief, I found that certain facts are required to be incorporated. The point is short, but the facts, because the matter had gone to Supreme Court also.
Yes, my lords.
So those facts, that will take some time. Therefore, it will come on Monday.
My lords. My lords, just one thing I wanted to show, my lords, if your lordship will permit me, there is an inspection report which I have actually annexed to my writ appeal, which shows that there was a recommendation of provisional permission for the college in the year 1993, which is at Annexure 13, my lords.
That is material.
Yes, it's there on record, my lords. Yes, yes. Grateful, my lords.
Item 18.
May I please, your lords? The conducting council is also matter may be taken up on Monday.
Yes, Monday. Monday, no, after vacation.
Item 19.
My lordships, item number 19 relates to the admission of.
Oh, you have again come. So is there any improvement?
My lordship, I had a meeting with the director, and as per the orders of this honorable court, I had submitted the number of students. Lord, I also received information from him on the status of the admissions. Only 3 students have got admission out of that. Apart from that, what the director had informed is they would be looking at neighboring schools and government schools to provide them admission. My lordship, my point here is the very essence of why I have filed this PIL is that getting admission in a government school will not serve the purpose for students who are going to receive admission under section 12(1)(c) of the RT Act. Lordship, there's an online portal which is only meant for private schools. Now, after assigning them a certain school, and then because the private school is not giving them admission, and then again taking them back to government school, my lord, what is the role of the government here then? They can directly go and take admission in that case. Lordship, around more than 50 students are being affected.
My director is online, my lord. He can approach, my lords.
Yes.
We have received a list of 63 students from the petitioner, and we have already intimated the VO Bhubaneswar, as all of them belong to Bhubaneswar. We have intimated them to take admission in government and also aided school.
No, Mr. Director, the question is that if the policy prescribes that certain percentage of seats in the private schools shall be filled up through you, then whether those seats have been filled up or not.
Yes, my lord. That percentage we had allotted last time also. I told we had allotted to the schools, but in two entry level. So they have taken one entry level, and these only 63 students, they have not been taken admission because the schools have taken in the entry level. But we have already intimated them to apply in the third round of lottery. But they didn't participate. Only 3 students participated, and they all have been allotted schools.
All right. So according to you, the what is the percentage?
25%.
25%. Whether those 25% of seats have been filled up in each and every private school in the state?
No, in the neighborhood, because
Around Bhubaneswar.
No, it's a national policy. It's a national policy, and if that is required to be followed, that will be followed by, should be followed by you. So can you tell us?
As they are in the class, there may be some of them pre-primary and some are primary school, primary level at the entry level class 1.
Mr.
So
you
they
will
will
have
be given at
to, you will have to evolve you will have to evolve a system to implement that policy, so that everyone knows that these are the number of seats available in these schools and which are to be filled up and how. If you don't have policy, you frame that, but everything should be in public domain. Every citizen, every resident of Odisha must know that this seat is available in that school, so that he may claim. He may not get. There may be many reasons. You are saying that you are following the lottery policy. You can follow that. But you will have to make a statement that all the seats in the private schools against that quota have been filled up. So that is the only question. See, a boy or girl or a guardian goes to you just to seek admission of his child, and you say that, all right, we are giving you admission, that is a school available. All right. We cannot say that the government schools are inferior to the private schools, but you will have to ensure that the private schools give admission against that quota.
But can they be taken admission far off places? They have to be taken admission in the neighborhood school.
All right, but there are two aspects. One, you may say that, see, in one school, 25 seats are available, but there is no child in the neighborhood who can be admitted in that school.
Yes.
And therefore, those 25 seats cannot be filled up. You can take this stand, we will see.
We'll take a stand that if the neighborhood schools are available,
you cannot take the stand orally. You will have to take a stand on affidavit.
Okay, my lord.
Yes, that is how we can proceed. What can we do?
My lordship, the vacation will begin, my lord, and if these students are not enrolled?
See, we are not about individual students.
It has to be implemented across the state.
Across the state, and the individual students, we don't know whether they can be given admission in a particular school.
My lordship, we are not demanding any particular school. My lordship, as per, I had also requested the director
See,
to at least...
if a child of, say, 7 years of age is required to be admitted in a private school which is 15 kilometers away from his house.
It will not serve.
So that will not serve the purpose. And the purpose is that these children should remain in the family also. And that travel time should be minimized.
My lord.
So therefore, do you have any policy? How do you proceed in such matters? Mr. Director.
May not actually in the online system itself, we have fed that all the conditions are acting as per
Where
ATI.
is that? Where is that? Where is that?
As per ATI, only in the neighborhood, within 1 kilometer of their residence.
No, where is that your policy? Is the policy on record?
Yes, we have notification 2017.
Whether that policy is on record?
No.
Yes.
All right. Let an additional affidavit be filed on behalf of the state of Odisha, bringing on record the policy prescribing procedure for admission to.
There is a one policy at page 39, annexure 4.
Just a minute. Please go through this document. All right.
My lordship.
We are adjourning the matter for Monday. Please go through this document, particularly annexure 39. Annexure 4. Annexure 4 at page 39. So tell us whether it lays down any procedure or not, and whether something further is required to be done.
My lordship, may I submit one thing? My lord, there are 4 specific schools where, even though they were allotted those schools and then admission was denied by those schools. Lord, if at least the government can submit whether the neighboring areas of those schools have been
Which are
filled up.
those schools?
Lordship, it was there. It is mentioned in the IA, BJEM school, St. Xavier's, Khandagiri. Lordship, in page number 3. At least in these neighboring areas, whether all the private schools and these particular schools, have they taken 25% admission or not?
Yes. Have you filed any reply to this?
No, my lord, no reply. On last occasion, director has appeared and has explained the facts. If your lordship permit me, I can file and reply to this.
No, deal with this.
My lord.
And counsel appearing on behalf of the petitioner has drawn our attention to paragraph 4 of to the contents of IA number 5770 of 2024 to submit that despite having been allotted schools, at least 70 students have been denied admission by such schools, namely BJEM, BJB Nagar, Xavier's High School, Khandagiri, Xavier's High School, Kedar Gauri, Xavier's High School, Satyanagar, and GD Goenka School, Japni Block. Are these schools are minority institutions? 2, 3, and 4?
No, my lordship, they're not minority.
Minority. No, not minority.
Not minority.
All right. Let's list this matter on Tuesday we will take up.
Lordship, Tuesday is the last working day,
Or
my Lordship,
Monday.
Monday.
In the meanwhile, yes, ma'am. In the meanwhile, let an affidavit be filed by the opposite party, concerned opposite parties, dealing with the averments made in IA number 5770 of 2024. Yes.
My Lord.
Item number 20.
In this case, on day before yesterday or during course of hearing, your lordship wants to know whether the amount which has been deposited before the honorable apex court, that is rupees 63 crores sum of, whether that includes the entire deposit made by all the customers. Ma'am. To that
No,
effect,
that is a condition for bail. That is material.
Your lordship, I am having a affidavit to that effect.
What are you doing? Do file in the registry. This is not the way.
Very much required, my lord.
Huh?
This affidavit is very much required because as page 27 of the affidavit filed by the EOW before the Honorable Apex Court.
File it in the registry. We will not see now.
I will take instruction on this.
Run counsel for the petitioner intends to file some additional affidavit. Let the same be filed in registry. What was the matter?
Matter is a student of engineering.
Yes, yes.
In 4 years last, thereafter 3 years grace period was allowed by the university regulation. That has already been crossed. Now he is seeking for a direction to allow him to proceed in the examination. These similar to this are not for passed in 2 words. So I am just passing to you. Regulation was already there.
Beyond the form of his.
Yes, this is the position.
Yes, I have already handed over the.
Do you have the regulation with you?
No, I don't have the regulation, but the part of the regulation is quoted in the.
That we have seen.
Quoted, but the 4 years, that is not a dispute. Dispute is not more than 7 years, you want further chance. So.
Only one semester is left.
Of the university and is not even applied for the subsequent semesters.
No, he has applied. As per my reputation under Annexure 4, I have applied your lordship, but I have missed the chance to appear in the examination. Registration I have made.
No, when were you admitted?
I am admitted in the said course in the year 2015.
Which course?
BTech, your lordship. BTech in civil engineering.
Which institution?
Institution name is Gandhi Institute for Technology, Bhubaneswar. Under Biju Patnaik University of Technology, Odisha.
When were you admitted? 2015.
15.
The petitioner was admitted in BTech in bracketed civil codes. Civil codes. In Gandhi Institute of Technology, Affiliated.
Affiliated under Biju Patnaik University of Technology.
Affiliated to Biju Patnaik University of Technology in 2015. Full stop. He has filed the present writ application for he could not complete his course during the last 8 years. Full stop. The tenure of the course is admittedly 4 years. Stop. The petitioner has filed the present writ application for granting permission for extension of the tenure for appearing in 8th semester examination.
8th semester examination.
Full stop. Next. And counsel representing the BPUT has submitted that the academic regulation prescribes tenure of regular course plus additional 3 years as a relaxation to weaker students to complete the course. So stop. After completion of prescribed 4 years of regular course, comma, quotes, comma, the no extension beyond 3 years for completion of the course can be allowed under the academic regulation. Do you have, what is the name of the regulation?
Academic regulation.
Hmm?
Academic regulation.
Under the academic regulation of the university. So stop. Our attention has been drawn to 2 orders passed by coordinate bench of the court, one dated 11/1/2024 in WPC number 16012 of 2021 and 2/1/2024 passed in WPC number 35056 of 2023. Party name dono wherein, comma, in similar circumstance, this court dismissed the prayer for extension of tenure beyond permissible limit. So stop. In such view of the matter, we do not find any merit in this application, which is accordingly dismissed.
Item 22. Item number 22.
Today also there is no representation on behalf of the petitioner. So stop. This is the second consecutive day when no one has appeared on behalf of the petitioner. This application is accordingly dismissed for default.
Item number 23.
May I plead? Well, in this case, well, Rule 15, well, 1D is under challenge, whereby the state government has granted an exemption of OTT pass, while NCT is the prescribed authority under section 23 of the RCT. Orissa teachers eligibility test.
OTET.
OTET.
Yes. So what is you are challenging what?
Challenging the, let's see, 15D, Lordship,
15(1)D.
my lord, D proviso, my lord.
D proviso
Proviso, my lord. Of elementary cadre rules, your lordship will find Orissa elementary education, method of recruitment, condition of service, teachers of officers, amendment rule 2019.
Let us see.
My lord. Page 59, annexure 6. That is also incorporated in book also. Education manual, it has been incorporated, although we have enclosed the entire amendment.
Where is that?
But amendment as annexure 6. Page 59. That is in exercise of powers conferred on 309, Malad. Proviso to 309. And the elementary cadre rules of 1997 is also a probably 309 rule, Malad.
So you are challenging this?
Malad.
You are challenging this?
On the ground.
Just a minute. Where is that provision?
Malad, may kindly turn to the relevant portions. That is at page 66, Malad. This amendment, 65, it starts. In the said rule in Rule 15, such and such amendment was incorporated. The relevant impugned portion is, your lordship, page
This
66.
is page 65. 65, page 65, Rule 8.
Malad.
Yes.
Malad, rule, sub-rule A, then B, Malad, the D. Thereafter D, it, Malad, the I and II, one I and II, then the next is the proviso, relevant portion. May I read the entire rule, Malad?
No, D.
1. Italic 2. Then the proviso, Malad. Proviso is under, Malad. Proviso is next page 66.
Proviso is not there, Mr.
Next.
Next page.
Next page.
Page 67.
66. Top, Malad. In top.
You are challenging that. Just
Yes.
a minute. Yes.
Well, provided that the teachers appointed against the advertisements published prior to 11 February 2011 are exempted from passing Orissa Teachers Eligibility Test 1 and Orissa Teachers Eligibility Test 2. Malad.
Yes.
Malad, on the ground, that rule is section 23 of the RCFC Act. Malad, may kindly have a glance.
Which act?
RCFC Act. Right of Children to Free and Compulsory Education Act 2009.
Education.
Yeah.
Malad, may kindly look to section 23.
Yes.
Qualifications for appointment
and terms and conditions of service of teachers. Any person possessing such minimum qualification as laid down by the academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Number 2, where a state does not have the adequate institutions offering courses or training in teachers education or teachers possessing minimum qualifications as laid down under subsection 1 are not available in sufficient number, the central government may, if it deems necessary, by notification relax the minimum qualification required for appointment as a teacher for such period not exceeding 5 years as may be specified in that notification. My lord, second proviso, provided that a teacher who at the commencement of this act does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 5 years. My lord, this was the original provision. My lord, the second proviso is the relevant. Provided further that every teacher appointed or in position, my lord, the significant, or in position as on 31st March 2015, who does not possess minimum qualifications as laid down under subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the Right of Children to Free and Compulsory Education Amendment Act 2017. It was incorporated by way of amendment in 2017. Inserted by 24th 2017 Act of 24th 2017, with effect from 1/4/2015. Therefore, 4 years relaxation was given by way of this amendment, that is up to 31st March 2019. Here, two things I want to draw out. Section 23(2) only empowers the central government to relax. And the second proviso is a further relaxation was given over and above the earlier 5 years. Further relaxation of 4 years was given by way of this amendment. That amendment I have also enclosed the Gazette notification in my brief, my lord. My humble submission before Lordship is, if this section will read with the Rule 18 of the Central RCFC Act, that says the same thing. Your Lordship may kindly have a glance. That is in that book, the Bear Act, page, your Lordship will find, the Central RCFC rule starts from page 20. And relevant portion is Rule 18 is the in connection with Rule 23. That is page 28. Page 28. Yes. Then I am permitted to draw your Lordship's kind attention to the Central RCFC Rules 2010. In exercise of power, Section 38 of the RCFC Act 2009, this rule was framed. No, you are reading which section? Which rule? Rule 18. That 18, is page 28. Please. Married. Relaxation of minimum qualifications. The state government or union territory shall, within 6 months from the commencement of the act, estimate the teacher requirement as per the norms of the schedule for all schools referred to in clause N of section 2. That is the definition clause. It covers all.
Matlab 2 and 3 is the relevant. Sub-rule 2. Where state government or union territory does not have adequate institutions offering courses or training in teacher education or persons possessing minimum qualifications as notified in sub-rule 2 of Rule 17 are not available in sufficient numbers in relation to the requirement of teachers estimated under sub-rule 1, the state government or union territory shall request within 1 year of the commencement of the act, 1 year of the commencement of the act, comma, the central government for request the central government for relaxation.
This we have seen.
3, my
We
lord.
have seen.
Then 3, my lord. On receipt of the request referred to in sub-rule 2,
We
the
have
central
read,
government, my lord,
we have read that.
my lord. The central government shall only after examination will relax, my lord.
Yes.
My lord, the act and the rules that the central RCFC rules, same line laid down that the central government will relax, not the state government.
Right.
But the state government has also framed Orissa RCFC rules 2010. The perimeter provision is Rule 16. If a lordship will, Rule 16 of the Orissa RCFC rules. That is in the book, Malad. Malad will find at page 188.
Yes.
Book of the 188. Malad will find Rule 16 in the same line of Rule 18 of the Central RCFC rule. 188 rule starts Orissa right of children to free and compulsory education 2010. Rule 16 is the relevant one for the purpose. That is page 198.
Yes. Please.
Malad.
Same thing.
Yes, Malad. The same Malad.
Yes.
Malad, institution offering so and so, the government shall request the central government for relaxation of prescribed norm, and on receipt of the request referred to in sub-rule 2, the central government shall examine the request of the state government and may by way of notification relax the minimum qualification. But my humble submission before Lordship is,
yes,
Malad.
Yes, please.
Malad. May I read, Malad?
No, not required. Not required, please.
Malad.
Please make your submissions.
Then my humble submission before Lordship is, in terms of section 23(2) and second proviso, 2 exclusively gives the power that the central government will relax on the request of the state government. So also Rule 18 of the RCFC, Central RCFC rules 2010, that says so. The state government have to make a request, then central government after examination by way of notification will relax. The same is also the state government RCFC rule 2010.
The affidavit has been filed. Have you filed?
In the next matter, counter, rejoinder and additional affidavit last occasion they have taken 2 times and they have filed. Matter has matured for hearing.
You are hearing?
Yes. My humble submission, this is one set. Another part is, your lordship will find, this is an act and rules. Rules framed under the act, and act is a product of section article 21A. Whereas the Orissa Elementary Cadre Rules of 1997 was framed in exercise of proviso, proviso to 309, my lord. And that is not a rule, my lord, under the 309. In the sense, my lord, even 309 occupies the field, but the proviso rule as framed by the governor, that is to go. Here, my lord, that is another set of argument. That here, the act has come into place with a clear stipulation the central government will relax and not the state government. And rules also framed by the state government, so also central government, respectively under Rule 18 and Rule 16, same things. My humble submission before Lordship is, here, when act and rules both says about relaxation, not about the exemption. And what the state government did, my lord, by way of 2019 amendment on 8th March 2019, they gave an exemption provisions, complete exemption to the teachers, those were appointed prior to 2011. But that exemption is not within the power of the state government. Even the relaxation power is not available with the state government. And here, state government has exceeded and given the exemption. Relaxation exemption, I have not to explain. It is, therefore, my humble submission before Lordship is, it is beyond the competency of the state government. And thereby what has happened, the prejudice is, the teachers.
That prejudice we can understand.
The qualified teachers are not being getting.
All right. Yes.
And only another aspect, NCT rule regulation, that says the qualification prescribed by, that I have also NCT regulation, your Lordship will find. NCT regulation that I have enclosed to my brief, and also the other briefs it is available. That is at page 69, annexure 8. NCT regulation 2014.
Yes.
It says, my lord will find the relevant page is 70.
Yes.
That the qualification for recruitment, then the small a and small b, B is relevant. For promotion to teachers, the relevant minimum qualifications as prescribed to the first and second schedules are applicable for consideration from one level to the next level. My lord will find. One level to next level. My lord, your lordship may kindly peruse the bottom portion, that primary and upper primary schools, minimum qualification as laid down by NCT by its notification dated 23rd 8th 2010 as amended time to time. 23rd 8th 2010 notification that we have enclosed in the present brief in annexure 2, my lord. Annexure 2 is the notification, 23rd August 2010. The qualification prescribed, my lord.
This is for promotion.
This is also qualification prescribed by the NCT is applicable for promotion. The qualification prescribed is under the NCT notification dated 23rd August 2010.
No, when you are referring to 4B,
my lord,
it refers to for promotion of teachers.
Yes, my lord. From one level to another level.
Another level.
My lord.
Minimum qualification as applicable for consideration from one level to another level, next level are applicable. So this is for promotion.
Yes, my lord. The same qualification which is applicable for recruitment, appointment of teacher, that is also applicable for promotion. That makes it clear.
No, but why are you referring to this?
My lord, because the rule 15 deals with seniority and rule 11 and 15 of the elementary state. My lord.
Maximum you can argue on this basis that the persons who have
my lord,
that qualification is for promotion. Is there any qualification prescribed by NCT for recruitment?
Recruitment and also promotion. It makes it, the difference was closed, my lord, that for recruitment, the qualification as prescribed by NCT is applicable. So also, as per section 23(1), and also promotion, the very same qualification which has been prescribed by the NCT notification.
Again, we are saying this,
my lord,
that if it is held that 15(1)D is intravirus, all right,
my lord.
If it is, this provision is held to be intravirus,
my lord,
then a person who does not have the qualification, according to you,
my lord,
will be qualified to be appointed. But because of this provision, he will not get promotion because he does not have that qualification which is required for promotion.
My lord.
So you that is different.
My lord. My humble submission before lordship is that the prescribing a exemption is beyond the jurisdictions of the state government.
That we understand. We in fact, Why are you referring to this? We don't know. A, let us see A. A is qualification for recruitment, B is for promotion.
But the marginal heading shows it is recruitment. And A is recruitment, B is, so for A and B, both are scheduled, for first schedule and second schedule, for both it is applicable.
Malad.
Where is the schedule?
Yes, Malad. Schedule in the government, sorry, NCT notification dated 23rd August 2010. That is annexure 2 to my brief. That your lordship will find.
In annexure 8 itself, it is there.
Malad.
Annexure 8.
Malad.
First schedule and second schedule are there.
Yes, Malad.
There itself.
So this will apply, 3 will apply.
Malad, may kindly turn to the NCT notification, Malad. That is annexure 2, the qualification prescribed. Page 29, Malad, of my brief. Malad, the qualification prescribed by the Malad NCT are 2 parts. Malad, the teacher qualification is separate qualification has been prescribed for class 1 to 5. And the second part is separate qualification has been prescribed for class 6 to 8. Malad, your lordship will find at page 29, annexure 2, where the academic qualification, training qualification, so also TT, pass, has been made compulsory. Your lordship will find. Page 29 of annexure 2, Malad.
Yes, that therefore you could have relied on this.
Malad.
So instead of referring to B of that, you could have referred to A.
Annexure 8.
Annexure 8, rule,
Malad.
rule 4A.
Malad.
Or regulations, regulation 4A.
Malad.
Not B. And then 4A plus the first schedule, 3, item 3, and plus the notification which you are referring to.
Yes, Malad. That notification is
annexure 2.
2, Malad. Malad, may kindly turn to
that we have seen. So why for 4B we are not able to understand this.
Your lordship, may I, Malad, may I be draw kind attention to the, instead of the regulation, your lordship straightway to this notification. Notification is to hold the field.
Notification is because of the regulation.
That this notification in pursuant to section 23(1).
Which notification?
Malad, this NCT notification under annexure 2. That is 23rd August 2010. Malad, what the
2010. The regulation is of 2014.
2014. Malad, 2010 regulation, Malad, the 2010 notification came, Malad, in exercise of power under section 23(1), Malad. What 1 says, Malad, 23(1), your lordship kindly have glance. Again, Malad.
After this regulation 14,
Malad.
No other notification come out.
Malad.
No other notification come out.
Malad.
In consonance with regulation 2014.
No, subsequent notification, recently I have come across, subsequent notification not with regard to giving exemption. The exemption as has been given by the parliament by of amendment in 2017. Thereafter, with regard to the relaxation and question of Malad, the relaxation only.
Counsel, our question is different.
Malad.
And our question is not against what you are submitting.
Malad.
You are referring to NCT regulations.
Well,
right. So clause A of rule 4, regulation 4,
Malad,
prescribes the qualification for teachers.
Malad.
All right. Then it says upper primary so and so shall be as given in the first schedule annexed to these regulations.
Annexed to these regulations.
All right. Now, when we come to the first schedule, come to item 3.
My lord, 3.
Primary and upper primary.
My lord.
For class 1 to 8.
My lord.
Minimum qualification as laid down by National Council for Teacher Education by its notification dated 23/8/2010.
My lord.
All right.
Yes.
So this is there, and therefore, what was prescribed in 2010 has been taken note of
here
in the regulation of 2014.
My lord.
Therefore, you are not required to refer to clause B. Clause B is for promotion.
My lord.
All right.
My lord, the 2010 notification that clearly prescribed that your lordship may page
that we have seen.
That the academic qualification, training qualification, and TT pass.
Yes.
And that is for class 1 to teacher for class 1 to 5 and teacher for class 6 to 8.
Yes.
That is why my humble submission before lordship is the 2019 amendment, which was brought in exercise of second proviso to 309 by the state government. It is not the relaxation. They completely give an exemption to the qualification. Whereas the Central Act, which was amended in 2017 by Parliament, my lord, and incorporated the second proviso to section 23, that says the teacher in position shall have to acquire within 4 years from the date of commencement of the Act. Act was given effect with effect from 1/4/2015. Therefore, 4 years means it is up to the 31st March 2019. And the state government adheres that brought this amendment.
All right. Yes.
Right from the beginning.
Yes, completed. Have you completed?
No, actually, today these matters have come because notice has not been issued in the first and last matter.
No, in second
case counter result everything.
No, but in the second case, this has come for fixing a date.
Yes.
Your lordship.
Yes, my lord.
But
My
you
lord,
have heard.
last occasion, no, last occasion, my lord, reflected in the order.
The first commission you should have been made, but he started hearing. It has come for fixing a date.
Your lordship.
He continues for hearing of the.
They have taken, my lord, two, 3 occasions.
All right, whether affidavits have been filed.
Yes, your lordship. In the your lordship, in the sub item, that is a main case, your lordship, 17780 of 2023. Your lordship on 4th of April has granted time of 1 week to file an affidavit. Thereafter, they have filed an affidavit and we have also filed an objection. Pleadings has already been completed in WBC number 17780 of 2023. But the matter could not be taken up due to the at the end of the list, your lordship.
All right.
Your lordship, kindly have a glance to the
We are bound by the order which we had earlier passed. So today we will not hear on merits. We will fix a date and we will fix a date and time also.
Yes, your lordship.
The only ballot I have with an application, interim application. The reason is, in the meantime, all these petitioners are the qualified teachers with TT qualification. They are not getting the promotions. Whereas, on the other hand, persons not having qualification, they are getting promotions. Now they are taking steps, that is only I pray, if qualified persons are being promoted, we have no objection. At least non-OTT candidates may not be promoted.
See, unless the law is declared ultra-virus, they can act on that. List this as jointly requested on behalf of the parties. Let these matters be listed on 19th June to be taken up at 2 p.m. 2 p.m. को है ना? 2 p.m.
Lordship, 17780 of 2023 may be taken as lead case, your lordship.
We will see that.
Oblige, lordship.
19, we are reopening.
No, 18th we are reopening. 18th is reopening.
18th we are.
Kindly 20 or 21.
20th. All
Yes,
right.
my lord. 20.
20th, 21st?
20.
21st.
My lord.
The Friday,
Friday,
21st is Friday.
my lord.
21st is Friday.
20th, 20th.
24th will be.
24th,
2 p.m. my lord.
2 p.m.
Oblige, your lordship.
And give us all the provisions
In my lord.
together.
Compilation.
All the
My lord.
provisions.
My lord. My lord. Oblige.
Statutory provisions only.
Only my lord.
Item number 24.
Yeah, please, my lord. My lord, we have filed this public interest litigation with respect to non-inclusion of two prime parking area spots of Cuttack, that is the Gorishankar Park front area and the backside area, in the tender which was floated by the Cuttack Municipality Corporation on 6th March 2024.
So what do you want?
My lord, let notice be issued. My lord.
No, no, not you want the council, but what is the prayer or what?
My lord. My lord.
Relief?
My lord, the prayer is that the area, the Gorishankar Park front side and the back side parking area has to be included in the tender list, my lord, since it is a state largesse, my lord.
Tender?
My lord. My
That
lord.
we cannot do.
My lord, let me apprise, my lord. On 15th March, my lord. On 15th March, my lord, we came to know that they have not included it just because they want to favor some private individuals, and they are on the process of that, and they have settled it in favor of some private individuals, my lord, without tendering the same, which is not the mandate of law, my lord. On 15/3, we gave them a letter inquiring as to why it is not included in the tender list and in the tender, and there was a list appended to the tender, my lord. And these two parking lists were not included, even though it was included in the previous years, my lord. And after that, my lord, they did not give us any reply to that, for which we have approached this honorable court. And my lord, the importance is, my lord, those areas are the prime parking spots, and if it is not auctioned, my lord, if it is not put in the and my lord, and it has been settled in favor of the private individual, that is the information we have got. And if it is not auctioned, my lord, the entire area, that prime area, will be, my lord, traffic stricken, my lord.
This matter will be taken up by the same bench? Cuttack.
Can be taken up by the same court of because I think
Because I am yet to move around the city of Cuttack. So I don't know anything about it.
Today is the bench.
Today might be at 2 o'clock, the judgment they have not, because
All right.
it mention can be made, no, motion can be made there.
Let it be listed before bench, so and so. This. The bench, let the matter be listed along with WPC so and so. Before. 2140. Let this matter go out of our board to be listed before the vote full stop. Let it be notified to be taken up today along with WPC number. You go today.
My lord. Grateful, my lord.
Order me to I'll order anything.
Item 25.
May I please? Lord, this is a PI petitions. The petitioner challenging the illegal inaction of the authorities in constructing a Kalyan Mandap on the Gochar land.
Item
25.
Yes. EIL for?
Well, my lord, the Gochar land, on the Gochar land without sanction, some persons are constructing a Kalyan Mandap. Therefore,
Private.
my lord,
Private persons.
Well, that is, we are, the claiming of the petitioners are that some hooligans of the local peoples are trying that, whether that has been sanctioned or not, but it has been on under the contrary of the law, because the grazing land of the Gochar land cannot be changed.
So, Mister, you have filed a PIL.
Yes.
So before filing PIL, whether the petitioner inquired as to who are making those constructions?
Well, I have already represented before the.
Representation will not do. This is not PIL for representation. If you file PIL, you should have at least inquired as to who are the persons who are making construction, as whether the construction is being made by the government or the local authorities or private persons. Those constructions are being, without this.
No, under these circumstances, my reply to that extent, my lord, we have gone to the Tahsildar of the concerned locality and representing and stating that some persons are constructing a Kalyan Mandap in the name of the Kalyan Mandap. We are obstructing that. These are the Gochar land. As per Annexure 1, it is clearly reveals that these lands, though it is recorded on the name of the government and it is meant for the Gochar land, my lord. Thereafter, we have represented before the Tahsildar, the Gochar land has been encroached by somebody and constructing the land, and they are telling that this is for a Kalyan Mandap.
Everything is vague. Some persons are doing something, then you went to Tahsildar, someone is doing what? Nothing. There is nothing.
No, I have annexed, my lord. I have annexed Annexure 2, 1, 2, and 3, my lord. Your lordship.
Must be residents.
Appear to be one kind. Except petitioner number 8. 1 to 7, they are all appears to be agnates or cognates.
Oh, Mr. The petitioners in the present rate application in the nature of public interest litigation allege that a construction in the name of which mandap?
Kalyan Mandap.
Kandyal Mandap is being made over a land, a Gochar land, contrary to law. Stop. Next. There is no statement in the writ petition as to who is making the said construction and at whose instance. Stop. The readings in the writ petition are completely vague. Stop. Further, most of the writ petitioners appear to be belonging to the same family of village Chakhari in the district of Balasore. Stop. In such circumstance, we are not inclined to entertain the present writ application. This application is accordingly dismissed. Stop. Next. However, the affected persons, the persons affected by the construction, if any, over the Gochar land, may raise their grievance before appropriate forum in accordance with law. Yes.
Item number 26.
We have already, before the collector, and my lord, with due apology, my lord, I can understand that. If your lordship will kindly glance to the Annexure 2, it has been received by the Tahsildar, concerned Tahsildar, who is the person concerned to that whether land is encroached by some other or not.
The petitioner shall also be at liberty to pursue the matter before Tahsildar. All right.
Item 26.
My lord, deliberate willful violation of the order of the Senate around passed on 2/12/2020.
Disposed of,
I,
whether it has been disposed of.
my lord, though they have processed, he has disposed of representation, but he has not taken any action against the encroachers.
Was there in direction?
Direction, my lord, the Tahsildar has shared this order.
The order has been complied with.
My lord, though complied, but no action is taken against the
Was there any direction issued by this court?
and the only direction issued by this to
That has been done. The order of this court directing
but my lord, as per our instruction, the enclosures are now
directing
raising
consideration
construction.
of the petitioner's representation by and representation and passing a reasoned order thereon has been complied with. The top learned counsel for the petitioners, however, submits that the opposite parties, that the contemners have not taken further action. Full stop. There was no such direction issued by this court in the order dated 2/12/2022, passed in WPC number 32357 of 2022. Full stop. No disobedience of this court's order is made out, comma, in our opinion, full stop. This application is accordingly, the contempt proceeding stands dropped accordingly. Yes.
Item 27.
Your lordship's order is not yet complied.
Let us see. What was the order?
There will be direction to consider the representation are taken this sum. That order has been taken, the decision has been taken at 24/4/2024. My friend, Melody, this is sent by director. I will give you a copy.
Give him. It is stated by learned AGA that the petitioner's representation has been disposed of by an order dated 24/4/2024, comma, in compliance of this court's order dated so and so, passed in dated 7/2/2023, passed in WPC number 2804 of 2023. Stop. In such view of the matter, the contempt proceeding is dropped.
Item 28.
May I please, my lord? This is a contempt proceeding against the contemner.
Let us see the order.
My lord, at page number 8-9, your lordship. The relevant page is 9. My lord, this was a prayer for releasing the rehabilitation.
No, let us see what was the direction.
My lord, in view of the above, without expressing any opinion on the merit of the claim of the petitioner, we dispose of this writ petition, directing the opposite party number 5 to proceed with the matter with expediency and dispose of the grievance petition, answering the claim of the petitioner at the earliest, preferably within 8 weeks.
Yes. All right. 6 weeks time, 8 weeks time is allowed for learned AGA to seek instructions and inform this court as to whether this court's order dated 5/12/2023 has been fully complied with or not. 23 passed in WPC number so and so has been fully complied with or not.
All right.
Item 29.
It has been complied with detailed order has been passed on the representation.
Complied with? Yes.
Item 30.
This is the second contempt. In first contempt, there is a direction. Lordship may see the
But whether the order has been complied with, let us
That-
see the order first.
That is the order at page 9, my lord.
Yes.
There is a direction to dispose of the petitions, refundations,
Yes.
but that was not disposed of within the time frame. Then I filed a fast contempt. Again,
Whether it has been finally disposed of or not.
not yet.
Compensation.
Same order.
Come. My lord.
31.
May I please, your lordship? A non-compliance of the order dated 17/8/2023 is under annexure 1.
I think my friend was day before yesterday, similar.
Yesterday, the similar matter was dismissed on the ground that the representation to annexure 2 series dated. On that day, I was not bring the writ petition copy. The annexure 2 series dated is 15/5/2023.
Your representation was not there, nothing was there.
Representation, I bring the writ petition copy.
A writ petition,
Because the writ petition is tagged with the contempt, because the writ petition number is mentioned in WPC number 16791.
Asha, let us, for the experiment's sake, see your writ petition. Give me your writ petition. So this was your representation.
Yes, your lordship.
How was that communicated?
Communicated that slip I have filed, my lord, in the original slip I have filed in the writ application, that for which that is your annexure 2 series, because there is the representation is annexure 2 and the postal receipt is annexure for which this is
Postal
mentioned
receipt will not do.
annexure 2 series. my lord.
Postal receipt will not do.
Postal receipt is annexed.
Postal receipt.
Postal receipt was there.
वो कल जो डिसमिस किया था ना बस एक। कौन सा है? What is the number which we had dismissed yesterday? What is the number?
Day before, I can get that.
Because the poor persons, those whose land was enforced by the opposite parties, contemners, for not giving compensation. For which that earlier the lordship direct to the
672 of
35 item.
35.
30.
No, yeah. Right. Oh, what are they?
The land was acquired by the opposite party contemner for widening of the river embankment without any notice to the petitioner, without giving any compensation. And forcibly built the river embankment with constructing the pillar, boundary pillar, for which I approached this honorable court, and this honorable court is pleased to dispose of my writ petition.
But that is not the way. That is not, you could have approached, I was told, which court? Lara court. You could have approached. Why are you coming here for disposal of representation when they can decide?
Because without any notice or any.
So therefore, you could have gone there to Lara court.
Already the honorable court passed the order for.
Land acquisition and
Civil court is there, there's a private party's land cannot be possibly taken by the state government. And they have not given any notice under section 80 also, nothing, only writ petition is filed saying that representation may be considered, may be given compensation.
That already the direction was there.
And if they are poor people, let them go to legal service authority.
Because the
Legal service authority can take steps.
Earlier, your lordship has been pleased to direct the opposite parties to consider. So your lordship may kindly call for the instruction that is sufficient to comply the order.
No, we are in contempt jurisdiction. We have limited role.
Because your lordship's order is still not complied.
Your lordship's order, we have seen your representation.
Item
They are
32.
poor people. They are writing letters in English. They don't know what has been written.
The English means poor person is not that the persons are not.
They are
educated.
filing representations and
Yes,
just
sir,
taking
now
that.
I-
Go to
Obliged to.
see. Pursue remedy before appropriate forum.
Obliged to.
Item 32.
May I please, my lord? Item 32, my lord, is the second contempt, my lord. The order was passed on 14/7/2023. Direction was issued to consider the case of the petitioner under Annexure 1, my lord. The representation disposal, my lord.
Where is the order?
Order at page 12, my lord. Page 13 is the relevant part, my lord. Thereafter, the petitioner first contempt was disposed of.
This is also the compensation under Right to Fair Compensation Act.
And where is your representation?
Representation was submitted in the writ petition, my lord. Thereafter, while communicating the order, the lordship may kindly see page 17 of the contempt petition. The order, along with the writ petition, was duly communicated to the opposite party.
So we have serious doubts whether you had filed here any representation or not.
My lord, the representation.
You are coming with a copy of your representation to this court
My lord.
for this court to direct disposal of representation. Then you are going to the authorities with a copy of this order and a copy of the writ petition in which representation is enclosed.
My lord.
This is not the way.
That was the order passed by this.
That was the order. This is the order. This is how you are getting the orders. The court presumes that you must have filed representation.
The petitioner already filed the representation.
Where is that?
That has been annexed to the writ petition, my lord.
Where is your writ petition?
My lord, I have the representation.
Yes, show us. So how was that communicated?
The communication receipt has not been filed, my lord.
Then what is this? It's a kind of a scam happening in this court.
Sorry, my lord, but the communication receipt has not been filed.
Then how could you obtain an order from this court for disposal of your representation? And there is absolutely no proof that you had filed any representation?
He has approached, my lord. As per my instruction, the petitioner.
Where is the question of where is the proof?
Well, he has submitted it by hand, my lord.
Submitted it by orally?
By hand, he has submitted, my lord. But it has not been proved, my lord.
People are taking undue advantage of the generosity of the courts. Dekho, item number 32. The petitioner alleges disobedience of this court's order dated 14/7/2023, passed in WPC number 20410 of 2023, operative portion of which reads as under paragraph 5. Stop. With an allegation that despite the court's order said order, the representation was not disposed of, the petitioner filed a contempt application giving rise to CONTC number 8754 of 2023. This court disposed of the said contempt application with an observation to dispose of the representation if not already, to comply with the order dated 14/7/2023 if not already complied with. Stop. The petitioner has a grievance in the present contempt application that neither the order passed in the writ proceeding nor in the subsequent contempt proceeding has been complied with, and till date the petitioner's representation has not been disposed of. Stop. Next, it is peculiar to note that the representation which the court had directed to dispose of has not been brought on record. Stop. In response to a query made by this court, learned counsel for, in this regard, learned counsel for the petitioner has submitted that the said representation was brought on record in the writ proceeding. Stop. Learned counsel for the petitioner produced before us a copy of the writ petition, which according to him contained the representation. Stop. There is no proof. The documents as shown by learned counsel for the petitioner do not at all indicate that the petitioner had ever in fact filed the representation before this court, representation before the competent authority, before this court's order dated 14/7/2023 was filed. So stop. Next, in our considered view, based on such allegation, the court should not proceed in contempt jurisdiction. Stop. This application is accordingly dismissed, being devoid of merit.
Item 33.
I may pray, my lord. Liberty may be granted so that the
Liberty, you should be prosecuted.
my lord, he has
Give
submitted.
us a chance. All right. Let this be an example.
I'm sorry, my lord. I'm sorry.
Just a minute. Just a minute.
I'm sorry, my lord.
उसको dismiss नहीं करना.
Lordship, I
No.
I apologize.
No. Sorry. I am sorry. Now I am sorry.
Lordship may be liberal, my lord. I'm sorry, my lord.
Let an affidavit be filed by which Tahsildar? Huh? Jaleswar. As to whether
In the district of Baleswar.
his office, as to whether his office had received any representation, dated which is no. Order of this court. Where is the order of this court? Again? Any representation dated 15/3/2022 before the order of this court dated 31/3/2023 was passed in WPC number 21077 of 2022. We will proceed against you. If answer comes that no such representation was filed, we shall proceed against you.
I may humbly
This
submit my lord.
practice must stop.
I may humbly submit my lord.
Oh, just a minute. Just a minute. No, before that. Any representation before the order dated 14/7/2023 was passed for disposal of the said representation.
I may be pardoned to submit, my lord.
Yes.
My lord, since the petitioner by hand he has given the representation, my lord, there is no proof, my lord, that they can provide.
There is no proof, then we will not record that in our order. But please be careful in future.
Obliged, my lord.
If any such thing happens in this court, I will initiate proceeding against them. Let there be one instance. And you will see the example.
Lordship.
Just you come with a writ petition for disposal of representation. Whether the representation has been received or not, there is no proof. And only because some order has been passed, contempt. You should be prosecuted. You are prosecuting the officers. Yes. So whether reason order has been passed. Whether reason order has been passed.
No, my lord. Yes,
Where
my
is
lord. Order has been passed for hearing, my lord. And the petitioner reply annexure 5 series dated 15th March 2000 shall be examined by the Tahsildar, which is at page number 12, my lord.
Yes, that is there.
Yes, my lord.
But where is your representation?
My lord, at page number 13, I have filed the order copy along with the writ petition copy.
Where is your representation? Where is your representation which was to be disposed of? Where is that?
Yes, the petitioner has filed the writ petition along with the order copy, my lord. He has already
Do you
filed.
have a copy of the representation with you right now?
Yes, my lord, I have the writ petition.
Give me. Give us. Tell us, take instructions.
Obliged, my lord.
From 34.
May I please, my lords, that the petitioner, my lord, approached in the content application for non-compliance of the order of this honorable court. My lord, background of the case is that, my lord, petition being the
No, let us see where is the order.
My lord, first order, my lord, first, I have been quoted, my lord, in my body of the content petition. And you find place in page 3, paragraph 3, that ordering portion, that in course of the hearing, on the counsel for the petitioner submit that this is the amount which has been deposited by the petitioner pursuant to the auction held for the financial year 13-14, that will be issued to the authority to refund the same to the
So
petitioner.
there is no direction there to consider.
My lord,
No.
after this, my lord, I filed the annexure 1, my representation, after this, my lord, I filed my representation annexure 1, my lord. Since annexure 1 not been, that is filed on 17, annexure 1, my lord, that is filed on 17/8/2016. my lord. Since that has not been acted upon, I approach the Honorable Court again in read petition that in 15,604, my lord, at page 12, the ordering portion, my lord, as 14, there my lordship is directed that however the end of the court is granted liberty to the petitioner to approach the authority concerned, refund the money deposited for the.
Which order you are reading?
That order dated 24/8 at page 14, my lord. That WPC 15,604, 2017.
Yes.
My lord, that in the middle, my lord. However, in the end, this court granted liberty to the petitioner to approach the authority concerned for refund of the money deposited for the 13/14, which has to be considered in the merit according to law, pursuant to which petition filed a repentance of 17. That are annexure 1, which is according to not yet been considered. Then, my lord, after this, my lord, I filed an advocate notice. Thereafter, again, repentation. Since that has not been complied, I approached this Honorable Court by way of a contempt, that is 706 of 2018. That is annexure 4 at page 18. My lords directed, if not complied, then complied within a period of 2 months. That has not been complied. My one course, 25 lakhs rupees has been employed since 1913. And my lord, I'm a contract, but I could not have employed that money. I want that money has to be refunded to me. I'm a successful bidder. I deferred the EMI and other statutory
You seek
deposit.
instructions.
From 35.
Violation of order dated 16/3/2023, my lord. That is page 12, and the relevant page is page 15, my lord. Direction was given to the disposal of the OLR case.
Which annexure?
Annexure 1, my lord. Relevant page is page 15. The following direction are accordingly issued by this honorable. Direction was issued to dispose of the OLR case within a stipulated period, but till date not complied by the Tahsildar Khariar.
So what has not been done?
Matter related to OLR case, my lord.
Yes, what is the status, present status of that OLR?
That is till date not disposed of by the Tahsildar. And when it is listed 1/6/2023.
So whether you appeared on first.
Yes, 1/6/2026, that is page 20 and 21. I appear also page 22. I deposited all the certified copy before the Tahsildar.
Thereafter?
Thereafter, no listed. No listing, no action.
Yes.
26.
But the petitioner is also one of the parties to this kind of number one. Who had approached and why is not.
In the opposite party approached before the Supreme Court, but not stay order was passed. It is only issue notice, and the Honorable High Court also passed the status quo order.
Then what is wrong?
Till date not complied, as it is no stay order passed
The
by
matter is pending before the
Supreme Court.
So you had gone to Supreme Court.
No, opposite party.
Then
Because the status quo order passed by this honorable court at page 16, my lord.
page 16.
Yes. Direction was given to dispose of the OLR case, and till then status quo to till then be maintained by the parties. Against that order, the opposite party approached before the Supreme Court, and the Supreme Court also at page 27, my lord. Issue notice returnable within 6 weeks. I quoted status quo in respect.
This order has been stayed.
No stay, status quo.
No, status quo.
Huh?
Status quo has been.
Status quo.
Status.
Because of the order of the Honorable Supreme Court, Tahsildar cannot proceed with the matter.
Status quo relating to land mallet, not the order disposal, not for
We
disposal of
understand
the
that.
case mallet.
We understand.
Yes, ma'am. And this honorable court also passed status quo. Status quo
The matter
passed.
is pending before.
And after that, direction was given to the Tahsildar to dispose of the case mallet, OLR case.
But the matter is pending. Where is the Supreme Court's order?
Not page 26.
26, 27, that operator.
27 is the High Court judgment.
The petitioner has alleged disobedience of this court's order dated. Where is that order?
16, page 12, 16/3/2020.
16/3/2023. Passed by a coordinate bench of this court in WA number 534 of 2011.
534.
Oh, stop. It appears from annexure 4 that an SLP has been preferred against the said order of this court, comma, before the Supreme Court, which is pending. Oh, stop. In such view of the matter, we are not inclined to entertain the present contempt application. Stop. The contempt proceeding stands stopped accordingly. We should not proceed, Mr. Counsel.
Because the status quo relating to land mallet, this case, your lordship kindly see the direction of this honorable court. Page 16, the status quo also.
We have seen both.
Mallet.
There is a status quo order.
Yes.
The Supreme Court has passed an interim order that the status quo as granted by the High Court shall be maintained. That much we can understand.
Mallet.
It is true that the proceeding has not been stayed before the
Mallet. After giving status quo by this honorable court, also directed for disposal within certain period mallet.
Who?
This honorable court in passing the.
This honorable court had directed bad, but the matter is pending.
Yes, pending was the honorable Supreme Court also passed the status of same order mallet relating to case and disposal of the.
We have understood, but the question is whether we should proceed in the present matter. It's a contempt proceeding.
Relating to the OLR matter, you also kindly see the 4 decades are pending before the honorable Tahsildar. 4 decades. This is also mentioned in this order mallet. You also kindly see page 15, para 7 mallet. What the impugned order of
we have read, Mr.
Mallet.
We have read the circumstance in which the division bench directed for early disposal of the case.
Yes, yes.
All right, we have seen that.
And after that, status quo order passed by this.
Status quo was passed by this court that parties shall maintain status quo till disposal of that proceeding.
Yes, yes.
Against that, someone went to Supreme Court. The matter is pending in Supreme Court. So in the meanwhile, if we start punishing the officers during the pendency of the case before the Supreme Court, that will create a very
petition. Mallet, the opposite party not filed for any extension of time also. Mallet.
difficult.
If
Very difficult, Mr. Counsel. Though we are with you on the point that when the matter is pending since 1976, it should have been decided. But when the matter is pending in Supreme Court and notices have been issued,
they should have filed a petition.
we cannot advise them.
State government should have filed a petition explaining the position to extend the status quo in respect of the land in Supreme Court and same thing. And your lordship has seen that 1/6 both the parties will appear. In their presence, the order is passed. Both the parties who have appeared filed everything. And thereafter, Millard, the direction was given by September 4. It has to be disposed of. Orders copies should be given. Supreme Court has not granted stay. And they should have filed an application stating this is the difficulty, so we are not taking.
Either of the parties, even someone, otherwise.
Now
we
the
can be-
Supreme Court, Millard, when it will be 4 decades and they are in possession, that is the problem.
So, the situation is unfortunate,
Let
but
them file a petition, Millard, for explaining the position. So that at least that will be there. This is the difference because the pendency, no order is passed.
the simple stand which they are going to take is that because the matter is pending in Supreme Court and notices have been issued, therefore we are not proceeding.
And also stay order till that date.
Make an
Thereafter, no
application.
stay order that are
All
not
right,
also extended.
not for the present. Not for the present.
Item 36.
May I please, your lords? Non-compliance of order dated 2/9/2023. The content petition has been filed. Your lordship may kindly see page 10 of the content application, the operative portion of the order. After hearing the learned counsel for the petitioner and on going through the records, this court, without expressing any opinion on the merits of the case, disposes of the writ petition, directing opposite partner 1 to consider the representation.
Where is your
filed by the
representation?
petitioner by the annexure 5.
Representation.
Yes, my lord.
Annexure 5 to the writ petition.
Yes, my lord.
So where is that?
That I have not enclosed. I have
Not enclosed.
Your lordship may kindly see my writ application.
Sure.
That has been duly received by the authority, my lord.
File your strict instructions.
It's not to New York. It's National Highway Authority. of
National
India.
Highway.
Notice it.
Issue notice.
Yeah, my lord. All other matters same, my lord. But
Same.
Orders are different dates, my lord.
Let's ensure.
Item 37.
Obliged.
Your Lordship, in item number 37, I am appearing virtually in this matter, Your Lordship. Lordship, this contempt petition has been filed owing to non-compliance of the order dated 10/7/2023, passed in writ petition number 19744. And Your Lordship, in the connected matter, same order, but writ petition number is 19731. In both the contempt petition, I have annexed the representation by the annexure 2 at page number 8 in both the contempt petition, Your Lordship. Order was passed on 10th of July. I have submitted my representation on 21st of July.
No, but where is your representation which was required to be disposed of?
Your Lordship, this court had directed then at page 6, Your Lordship.
We don't know whether you had filed any representation or not.
Your Lordship, it is at annexure 2, Your Lordship, page number 8.
Annexure 2 is subsequent.
Yes, Your Lordship. Submitted.
That is subsequent representation. So there was some representation filed by you which was to be disposed of. That representation is not there on record. The petitioner has alleged disobedience of this court's order dated 10/7/2023, whereby the contemners were directed to consider the representation filed by the petitioner and pass an appropriate order in accordance with law within 3 months. So, the said order, the said representation, which was required to be disposed of, has not been brought on record. To stop, the petitioner has not been able to establish in the present case that a representation was in fact submitted before the authorities. Full stop. Based on such facts on record, we are not inclined to proceed in the matter. Stop the contempt proceeding. Accordingly, it stands just dropped.
Both the cases. Item 38.
My lord's judgment dated 21/9/2023 has not been complied. In paragraph 13, read application allowed by directing the state opposite party to regularize the services of the petitioner, my lord, within 3 months. But that has not been done.
Let us see.
My lord, the state council is the first instance it comes. And in page 26, paragraph 13, the operating judgment of the Honorable Court in division bench, in the result, the view of the discussion made above, herein above, and for the reason stated, this court is of the considered view that the order dated 2/11/2018 of Odisha Administrative Tribunal, Cuttack Bench, Cuttack, warrants interference and is therefore set aside. In view of the fact that petitioner has been serving continuously since 2008 till date in the post of cook cum attendant, and said post is not against a scheme, this could direct the opposite parties to consider the case of the petitioner for regularization in service, keeping in view the ruling of Honorable Supreme Court.
Instructions.
39.
Obliged.
Item number 39.
Mr. Rai, unmute yourself.
Yes.
Order. The contempt petition is filed challenging the order dated. Has not been complied with. This is the first content matter, my lord.
Which is the order?
The order dated 25/9/2023.
What was the direction?
It's not rehabilitation law. In the Sagar case. So in view of the lawsuit order, it has to await because my friend has done similar cases already, she should have pointed out. In the Sagar, honorable.
So we cannot proceed now. The matter is pending before the Supreme Court. So this is the order violation of which they are alleging. The petitioner alleges disobedience of this court's order dated 25/9/2023, first in WA number 1354 of 2022. The said order has been passed in the light of a common order passed in WA number passed on the same date by WA number 810 of 2021, bracketed State of Odisha versus Bindusagar Samantrai. Stop. The order passed in case of Bindusagar bracketed Supra is under challenge in Supreme Court. Stay as is there any stay?
Only notice has been issued and.
My lord.
How many cases are to be covered on the publication? That will be federal and also filed a
Stop. As the state has preferred an appeal against this court's order in case of Bindusagar Supra, we are not inclined to proceed in the present matter. in contempt jurisdiction. Contempt proceeding stands stopped accordingly.
Item 40.
May I please, my lords?
Obliged.
The order which
Adjournment
I
copy.
allege that has not been complied with is at page 2, quoted at page 2 of my contempt petition, my lord. This honorable court by order dated 15/3/23 disposed of the matter by directing the opposite party to
Where
consider.
is the representation?
My lord, representation was annexer 6 in that writ application.
Where is that?
No, that is, I have also put it on today's record also, my lord. That is, your lordship will find at page 11 of my contempt application, because along with that representation and along with the order of this honorable court, I made a representation after the, and that earlier representation is at annexer page 11, which was annexer 6 in the writ application. And your lordship will find that has been duly communicated by speed post. At page 13, your lordship will find the receipts of speed post, my lord.
Yes, seek instructions. And please comply with these orders. And in cases where you don't find that there is no representation, you should not consider. You just, unless there is some representation in the office received before the date of the order, you are not required to pass order.
Item number 41.
May I please, also, on behalf of Mr. Subhash Pradhan, praying for an adjournment, can be taken up next week.
Let us see what is the matter. Seek instructions.
Obligement.
Item number 42.
May I please, your lordship? This is second contempt. The operating portion of the order passed in first contempt, my lord, that is page 12. For 3 months' time was allowed for compliance of the order passed in writ petition, my lord. My lord, prior to this writ petition, where the contempt arises, there was a earlier writ petition which was inadvertently or due to communication gap between the petitioner and the previous lawyer, it was disposed of. But the honorable court granted liberty. If any cause of action survives, then he can approach the forum, my lord. Accordingly, I have filed.
You are alleging violation of which order?
My lord, that is lordship's page page 10. The order passed it.
What
That
is
is
it?
order dated 22nd August 2023.
Yes.
Thereafter, first contempt, there was also another 3 months' time was given to the contemptor. That has, they have also not yet complied. That is page operating portion, page 12.
Seek instructions. And tell them, please comply with such orders. And unnecessarily, these matters are being adjourned.
Obliged, my lord.
Item 43.
May I please, my lord? Order dated 11th September 2023 has not been complied, my lord. The operative portion of the order is page 12, para 8, my lord. In such circumstances, we direct the petitioner to file a fresh representation before the Tahsildar Samakunta, who will be a statutory authority for evicting the encroachers from the government land. The representation, leave of the which it has been wanted thereunder, shall be filed within a period of 15 days from the today, with all relevant documents, if any. On receipt of the said representation, the Tahsil shall take appropriate actions after inquiry and on affording opportunities of hearing to the persons, if any, encroaching the government land. Such exercise including
Yes, file your representation. Instructions.
Item 44.
4, my lord.
the petitioner here is a retired learned district judge, my lord. This honorable court has directed to pay his allowances which he is entitled to. White order dated 13/7/2023, which is page 10, my lord. Subsequently, he made a representation at page 12. Has been struggling for his pending allowances, my lord.
Paucity of funds. For paucity of funds, you are not paying him.
That
In spite of the fact that you have filed counter.
This honorable court has
counter
already
affidavit,
decided
admitted.
in view of the order judgment of the honorable Supreme Court that cannot be ground. Even that is quoted in the judgment of this court.
Who has not done it?
Lord, it is
Addressed to the.
There is no representation. In this case, there is specific direction.
No, it's a direct.
and there is an admission, my lord, also.
No,
So-
representation is direct to the district of Sundargarh. I obtain instruction from him.
Otherwise, we will proceed. And how the Sundargarh district judge will not pay?
Representation is made pursuant to the direction, page 12. Representation is submitted to him.
No representation, maybe who was required to pay? Who is required to pay?
Is there any requirement of finance department? Concurrence?
Because if there's being referred to, that there is a direction, the open number authority to pay the amount due to the petitioner. Accordingly, the petitioner made a representation along with the order to the London district judge Sundargarh. I find out from all the opposite parties who
Is one of the parties here.
All right, what was your grievance?
Lord, his allowances which he is entitled to.
Which allowance?
My lord, that is quoted at page 10. Your lordship may kindly see. This is the admission by state. By way of an affidavit, they have admitted these are house rent allowance, including medical allowance. Your lordship may kindly come to page 10. It is
Yes.
quoted in the order.
Yes.
This court made a order dated 8/5/2023 upon learned state council, called upon learned state council to file a detailed calculation showing the entitlement of the petitioner by way of an affidavit. In response to the same, the opposite party authority filed an affidavit on 16/5/2023, paragraphs 3 to 7 whereof are
Who had
expected
filed?
hereunder. Now
Who
here,
had
my
filed
lord,
the affidavit?
that it is humbly submitted that the house rent allowance as claimed by the
Mr.
petitioner.
Counsel, who had filed the affidavit?
The state council.
On whose behalf?
It is from the home department.
Home Department.
You have the petition copy.
It is not the writ petition. If I will lordship, I suppose it is additional chief secretary to the government home department.
Let a so cause be filed on behalf of the contemners as to why contempt proceeding be not initiated and they be not punished for deliberate violation of this court's order dated 13/7/2023, passed in WPC number 12045 of 2016. Place this matter on 26 June. Be there. All right, we will take up the matter on Monday, on Tuesday. Okay, let's remind me of that. No. See, if he is not required. It will come on Tuesday.
Milan.
The court will take,
In the meantime, I will also find out who is to pay.
who has to pay and how is that amount to be paid.
I'm grateful.
So 2 lakh.
So take up at your level.
No, I will.
Whosoever authority may not be opposite
This
parties.
one, to whosoever it goes, I will find out that.
Where
See,
is
when it
li-
comes
lying?
to administrative function, whoever violates a judicial order of this court, he may be a judicial officer, may be an officer of the government, all of them will have to be treated equally. All right. So in short,
I'm grateful.
Item 45.
May I please, Your Lordship? The
I
order
think that
dated
is, there is no dispute about his
No,
claims.
because it is to find that it is the amount due to pay.
So you should take
So
up.
no disputes upon them.
You should take up.
May I please, Your Lordship? My Lord, order dated 15th of March 2023 has not been complied with by the opposite party, my Lord. Whereas this honorable court was directed to consider the representation of the petitioner and communicate the result thereof to the petitioner within 4
where is
weeks.
that?
My Lord,
Where is the order?
page 8, Your Lordship. Where the petitioner submitted representation for insertion of his name in Bhulaka website of the state, my Lord.
What is there in the order?
My Lord, the para 3 petition will communicate this order and copy of the said representation dated such and such to the Tahsildar, and the said opposite party is directed to consider the, my Lord,
Nothing.
I'm sorry, my Lord, Xerox, my Lord, one line, my Lord. Consider the representation and inform result thereof to the petitioner within 4 weeks. Perhaps, my Lord, I'm sorry, Your Lordship, my Lord, one line.
Item 46.
Obliged, Your Lord.
Complied with.
No, your lord.
So a little similar matter, all not lowering that, it can be done within the attention. I talked to them.
Otherwise, he is a very serious counsel. He'll take you to task.
All the matters are similar.
All right. After it.
Item 47.
47, my lord, may permit me to withdraw it with a liberty to file a fresh petition, my lord. There are some typographical errors in the petition. I'm filing a memo.
Let us see what is the order. Typographical error we can ignore. Let us see the order.
No, my lord. A few opposite parties, contemners, their name have been inadvertently added, my lord. So I have to file a fresh petition, my lord.
Let us see, let us see.
Yes, my lord. Order is at, my lord, page 11, my lord, annexure 1.
Yes.
Your see, there is a direction for your, to the opposite parties to, intimate the association, so that the tender works are concluded. It is, in the order it is stated that the mechanical department of workers, have already, issued some circular, but they are the contenders before us.
But why are they violating?
Some other department, those which have not issued the circular, they should be
Yes,
made
ma'am.
parties.
Yes, my lord.
Department
In other
which those who have already complied the order, they have been made parties.
yes, my lord. That is my claim, my lord. I crave to withdraw, my lord.
We are not convinced with the allegation made in the present contempt application of any disobedience, of any act of disobedience committed by the contemners in relation to this court's order dated 11/1/2024, passed in WPC number 42193 of 2023. Stop. The contempt proceeding is accordingly dropped.
Orders item number 48.
Yes. That the defects as pointed out by the stamp reporter be removed within 4 weeks from today, failing which this application shall stand dismissed without further reference to the bench.
Okay, this, the, for the removal of defects, the order was the 3/3/23. That
It
not
is
complete.
noted that earlier also an opportunity was given to the petitioner to remove the defects by order dated
3/3/2022.
3/3/2022, which has not been complied with.
Item 49.
Will you call it preemptive order when say without further reference? Without further.
Item 49.
Yes. This is also. An order was given. Same order. We are not dismissing.
No, I say it should be dismissed, may not be taken out, we will also look at the prayer.
Yes, yes.
So there is not some, there's something else, also similar possibility.
50. Item number
49.
49.
He is regularly sitting over there.
Yes, two of your also after mark, who are sitting on Dharna.
Not identified. on behalf of the petitioner. This first of this application accordingly dismissed for default. Default.
Never moved.
Okay.
And defects are also not good.
The simple thing. Yes.
Dispose of.
Dismissed for default. Item 50.
Item 50, I'll take after vacation. One defect is there. We have not filed the requisite. In the meantime, we will file the requisite.
6 weeks time is allowed for the appellant. Item number 50. 50. Petitioner to remove the defect as pointed out by the stamp reporter. Item 51.
God bless.
In 51, my lord, there is a delay. It has been shown as 1058 days, but some times to be explored that during that COVID period. This is regarding that regularization of ULB teachers, and in some cases, all the matters are disposed of on the ground of limitation. So those matters are pending before the Honorable Apex Court.
So 1058 days.
That COVID period has not been
COVID
explored.
period 1058 days.
Yes, that they were disposed upon 14/12/2020. It starts from 23/3/2020 till it covers 29/5/2022. Maybe because all these matters that regarding that pending before the Honorable Apex Court, maybe the notice can be issued on limitation.
Regularization of NMR DLR.
No, you will be teacher. Not
Teaching as well as non-teaching staff.
yes.
Should notice on limitation will be later.
And we have framed a policy, madam. We have also framed a policy for regularization. Then
We will see, we are issuing notice on the point of limitation only.
well,
Item 52.
First type of cases when you are losing before the Supreme Court in some other's case.
no, in this case,
No. Similarly, situated persons in other departments. Have you not lost?
in DLR.
DLR.
Yes, madam. But
Why
sorry,
you
madam.
not taking up any.
Sorry, madam. I am here, madam.
No. Yes.
In fact, you should also identify the Supreme Court is holding Lok Adalat in July. In July. So some cases can be identified of the state government which are unnecessarily pending before the Supreme Court. That can be
At least
disposed of
RACP matters, a bunch of matters of RACP now pending for the Honorable Apex Court.
that have become infructuous.
No, it's not become the very small points are involved. It can be also disposed of.
Lok Adalat.
Yes, ma'am.
So you can give us the list of such cases. I had requested and Advocate General.
Well,
So you please just remind him.
I'll
And even otherwise, your advocate on record will be the best person to tell you
Well,
that what are the cases which can be disposed of in Lok Adalat.
Many of the cases you would have. Okay.
Yes, 52.
Item 52, my matter has become infructuous.
Infructuous. Item 53.
Please, my
My lord, here, pursuant to my representation by the annexure 3.
Yeah. 54.
May I please, your lordship? I will
Despite
under-
this court's order dated 6/12/2023. Second copy of the OMB has been filed. Has not been
Pardon, your
filed.
lordship.
Not filed. Has not been filed. Today, there is no representation on behalf of the.
Pardon, your lordship. I am appearing in the item number 54, your lordship.
So why have you not given this a second copy of the brief?
I undertake to file by tomorrow, your lordship. I undertake to file.
That the defect as pointed out by the staff reporter be positively removed by tomorrow. So place this matter under appropriate heading. If the said defect stands removed.
Item 55.
Obliged.
May I please, your lordship? Item 50 permitted to withdraw, my lord.
Withdraw.
Obligement.
Item 56. My lord, will remember this case we undertook. Now we have submitted the final pension papers to the AG, and we have also requested the AG to expedite. This is on 4/5/24. We have submitted the final pension paper. She is in receipt of the provisional family pension, as I have already intimated, my lord, from the last day. My lord, may kindly see this. Good, I put on. Madam, just kindly the next page. We have already sent the family pension papers.
This is over, Mr. Counsel.
That has not been.
Madam, may keep it to, Madam, may keep it to immediately after vacation. We will have a, Madam, the London AG will, the London.
We remember. Ravi. Let it come up. Let it come after 19th or 20th.
Okay.
20th, you please tell us if everything is done in the meanwhile, please let us know, even if we are not in a position to reach there.
Item number 57. My lord, this writ appeal has been filed against order dated 7/11/23. But before I take my lord to that order.
57.
My lord.
It is 123, man.
123.
Right, that's the order your lordship should see. So the writ appeal is maintainable at all. In the contempt proceeding, so was filed by the state.
So let him argue.
Let him.
No, but he can, if an issue is of maintainability is raised, of course, they will have the.
My lords have already decided it.
No, that's not it. Lordship will consider this.
My lords have already decided, and in many cases, my lords have already.
I have one of incidentally already counsel in another case, arising out of an order during the pendency of the contempt proceeding. The lordship passed this order. I have brought it.
This is the judgment on which we are relying
Not
upon.
satisfactory.
Yeah, recently,
Can that be a writ appeal against that?
this court also.
That's the order. That's the order.
That is the order. The lordship looks at that. Refer to the judgment of the Supreme Court in that case.
Recently, I would.
No, but Mr. All right, this is your this thing,
Right.
preliminary objection.
Yes.
Let me,
Just also look to
let us hear.
impugned order.
Let us hear him.
Yes.
No, not this one. Another, Mr. Prabhakar Behra was arguing for transport.
That transport matter
Ah,
regarding
yes.
that granting
We
of
have said it is maintainable
Yes.
against the.
This, my lord,
Lordship said maintainable, but in which circumstances?
Yes, yes,
We understand.
Yes.
Yes.
my lord, I will not take more time. I will take my lords quickly through the facts only.
No. Let us come to the order first.
Ma'am, the order is. It is 7/11/23. My lord, sorry, I am sorry, my lord. The order is 6/4/24 at Annexure 13 at page 121. It starts from 121, sir.
Starts at 120.
My lord, may kindly come to page 123. Heard Mr. B. Rautra, London Senior Counsel, and Mr. P. Kerath, London Senior Counsel appearing for the petition in the respective cases, Mr. Saswat, London Counsel appearing for the contempt. After hearing London Counsel for the parties and on perusal of the record as well as compliance affidavit filed by the contemners, this court is of the considered view that the decision taken by the opposite parties are not in consonance with the order passed by this court in the writ petition, which was eventually confirmed by the division bench of this court. In such view of the matter, the compliance affidavit is hereby rejected. However, on the request of the learning counsel appearing for the contemners, he is given 2 weeks' time to file a fresh compliance affidavit. Now, my lord, why I am before this honorable court? An order was passed, my lord. In our genuine understanding, we have understood the order and we have complied with the order. We file a compliance affidavit before this honorable court. Now, the order which you have passed remains. My lord, I bow down before saying anything. I will never say, my lord, that the order we have passed is correct. No, my lord, I cannot say. We have passed an order, right or wrong. Order stays, we have filed a compliance affidavit substantiating that, yes, by this order, we have complied the order of this honorable court. Now, that compliance affidavit is rejected. The order stands. We cannot file any further compliance affidavit, my lord. This is my predicament, ma'am.
So is this your submission that by rejecting your compliance affidavit, the decision which has been taken stands fast? Yes.
Yes.
Is this your stand?
Yes.
Because of
that's what I was trying to impress upon this honorable court. Because in a contempt, my decision, the decision which I have taken stands fast.
Yes, Mr. File your, we will decide it. File your reply.
No, the reply will be, that is on the basis of the record itself, it will also be looked to the order. What has happened in this case? Yes, also the copy of the writ affidavit, sir. The judgment was passed by the panel, by the honorable single judge. That judgment, certain observations were made. Here observation was made referring to the rules. That they complied with by filing a compliance affidavit. And filed the honorable single judge issued notice in contempt, and a writ application was filed and a contempt application was filed. When the matter was taken up, they recalled that order. That order was recalled. So as a result of which, writ application has become infructuous and the contempt application was also withdrawn. But subsequently, and they challenged before the division bench. And the division bench upheld the order, refused to interfere. Then subsequently, another order was passed, reiterating the same, exactly the same, wording same, again order was passed. So when the contempt application was filed, and they said that that we have already passed this order. Court said that this is not in terms of the order passed by the honorable single judge. So that was,
in fact, the order which they passed, they had earlier already recalled it. Lordship will consider whether it's an abuse of support or not on the part of the states.
Maybe abuse. The order which has been passed can be set aside.
Yes.
Can be passed, set aside with a strong observations, with cost. But the question is, and the simple question is, whether in contempt jurisdiction, you can say that this is no compliance. But if a decision has been taken, and if the rejection of the affidavit is washing off the decision itself, then it's difficult.
No, they have never passed. Well, let us not misunderstand that way. Decision is never passed.
That is the effect.
Not decision passed by the government was never passed, my lord. Lordship will kindly see.
All right, let us see the order first.
Yes. Yes. That was never passed, my lord.
Just let us. Not the order, the original order.
Original
order.
of the honorable single judge.
Yes,
Right.
that's-
That is at page. That is at page 81, para 7. Kindly see, para 7. We'll just, Lord, sequence wise, we will take your lordship to these things.
Just.
Yes, right.
At page 81.
Having heard the learned counsel appearing for the petitioners and the learned additional attorney counsel for the state opposite parties, and on a careful
Examination of the background facts. And my learned senior resident, so I start. My learned senior notary.
All right, let him.
And on a careful examination of the background facts, this court observes that the candidature of the petitioner has been disqualified on the ground that the petitioner were not having valid registration certificate by the Odisha Nursing Council. On perusal of the records, it appears that the petitioners, after completion of the course from the recognized government institutions, had applied for registration with the Odisha Nursing Council. Subsequently, they have been granted a valid registration certificate by such council. Further, it appears that such registration certificate issued by the council is required to be renewed from time to time. So far as the present petitioner are concerned, in their case, the renewal of the registration certificate fell during the time when the advertisement was published under Annexure 1 to the writ application. However, it is not disputed that the registration certificate issued in favor of the petitioner by Odisha Nursing Council was duly renewed, and that such renewal means revival of the original registration without any break, and the registration certificate originally issued by the authority continues to remain valid. Therefore, it cannot be said that the petitioner were not having the valid registration certificate. It also appears that registration number assigned to the petitioner also remains the same even after the renewal of such registration certificate. Further, on perusal of the fact of the present case, the court is also of the observation that merely because the registration certificate is required to be renewed after certain interval, it cannot be presumed that the same can valid certificate in the process of renewal. Moreover, it is settled law that when a certificate is renewed, the certificate continues to remain valid from the date of the initial issue until the same is lawfully cancelled or terminated. From the record of the case, it reveals that what the opposite party have not stated that the registration certificate has either been cancelled or terminated. Therefore, the conduct of the opposite parties in holding that the petitioner were not having valid registration in terms by the advertisement is not correct, and the same is too harsh. Moreover, this court also observed that the power under Rule 8(4) having been exercised by the government earlier, as it appears from the additional affidavit, there is no bar in exercising such power of relaxation in genuine and appropriate cases. In view of the opposite analysis, as well as keeping in view the factual background of the present case, this court deemed it proper to dispose of the writ application by remanding the matter to the opposite party number 1 and 2 to reconsider the whole issue. Again, keeping in view the aforesaid observation made by this court, as well as the documents under Annexure 10 and 11 to the additional affidavit filed by the petitioner. Let the petitioner approve the opposite party number 1 and 3 along with certified copy of this order within a period of 2 weeks. In such event, the OP number 1 and 3 shall do well to consider the same as directed by this court herein above and take final decision within a period of 2 weeks thereafter. Then this order, thereafter they passed the order under Annexure 5 at page 85. After this order was passed. Page 85, that is on 24/11/85 to 2023, 24/11/2023, they passed an order. And they passed an order as if they are sitting in appeal over the finding of the Honorable Single Judge. I need not place because this order, they recalled subsequently when the contempt application was filed. The order was recalled at page yes, that at page 97. Let's get it at Annexure 7, page 97. When the contempt application was filed, when the matter was taken up, they said like page 97. pursuant to the order dated 5/12/2023 passed by the Honorable High Court in WPC number 39529/23 filed by Normanda Das and others, and WPC number so and so filed by Priyanka Rani versus others, as well as the submission made by the non-additional standing counsel.
The problem is that if there is any disobedience, and if the court is of the view that the order has been disobeyed, then the only option which is available to the court exercising the contempt jurisdiction is to punish.
Right, that's correct.
So the learned single judge could have punished him. Learned single judge could have held him guilty. But if the rejection of that affidavit is altering the decision or interfering with the decision, then
The Lordship sees the.
if they are ready to face the consequence in the contempt proceeding, let them face.
You also observe that and expose it.
Go back to.
You also observe that and expose it.
No, ma'am.
No, expose it.
I will submit, ma'am. I will submit, ma'am.
No, see, the contempt proceeding is there.
Ma'am.
So contempt proceeding, learned single judge is at liberty to pass
Exactly,
appropriate order.
Exactly, ma'am.
So if you are aggrieved by that decision, you can challenge in appeal
Section 19.
Right, ma'am. Right.
under section 19.
Right.
If you have decided that it's good that you have taken the stand that the order which you had passed was correct order,
Ma'am.
and therefore
You also set aside that order,
if
set
you-
aside and
if you take that stand that the order was incorrect and still single judge is incorrect, then it's very difficult.
I was not on that, ma'am, because, ma'am, with great respect, I am not.
That order should be set aside. We agree.
Please allow me to
Set
submit,
aside.
sir. Allow me to submit.
Yes.
What I am agreed, madam, with great respect, I am not alleging anybody. Here, before, we were here before this honorable court in a writ appeal. Here, my lord, entirely different submission was made. My lord, I say this, consciously I say this. But before the honorable single judge, a totally different
All right,
submission is being made.
whatever, now the matter is before the revision bench.
My lord.
We will just clarify
My lord.
that the effect of that order will not be setting aside of
Yes.
the order which you have passed, but it is open for the learned single judge to proceed with
yes,
the
absolutely.
contempt matter. If the finally learned single judge is of the view that contempt has been committed, he can punish.
Right.
As you think, we are not in hurry. Have instructions.
My lord.
Have instructions and then tell us.
Yes, ma'am.
We agreed.
We agree, Lord.
Prior to read appeal, we set aside the order. We agreed to that. You also record our concession.
My lord, may I call it on Monday?
Monday. Because these are things. Sometimes the small issues turn to very serious things. Therefore, take a conscious decision.
You also observe that and so that let them take instructions.
As requested on behalf of the appellant, list this matter on Tuesday.
Madam.
Within first 10 cases.
Tuesday is the last
Within first 10 cases.
Last 10 cases.
Tuesday within first 10 cases.
Yes,
we don't know whether we will accept your resolution or not.
We have, in fact, we are appealing.
Very difficult.
But the resolution is not yet accepted.
No.
Because you are also adjourning matters, not that Dixon shows that it is not.
No, we don't know. Like the Chief Justice is one of the judges. That decision will have to be taken by the full court.
Full court, if your lordship, subject to Lord, if your lordship accepts our resolution, then let this matter come on 18 so that, or.
That is, don't worry. Don't worry. And if any matter is not to be taken up, and if you find that there is some urgency, you can make we take up matters on priority basis.
For admission item 58.
I think this matter, lordships were pleased to direct us, the rejoinder was filed by my friends, lordship wanted this matter to be posted after the holiday because of the election, the officers are concerned, and we will file a reply also. My friend Mr. Mohanty was conducting this case, so may I pray lordship take it up only after I have talked to my learned senior also, because
we want to.
If he gives consent, then only.
Not consent, he has informed me. I can't say no that.
Oh, you have not taken his consent.
No, I'm not.
He
I
just
informed my
informed him.
law senior only.
This is what he is saying,
Yes.
that you did not seek his consent, you just informed him.
That is one way of interpretation.
And he is right. Just information may not do. All right.
But I'm hopeful my senior will not so belie me.
With the, as requested on behalf of the respondent, list this matter on 24th of June.
Item number 59.
Your Lordship, I'm appearing on behalf of Mr. Durga Prasad Nanda, counsel for the petitioner. Your Lordship, this item is sub judice before the Honorable Supreme Court. Let it be listed any day.
Remember that where the Honorable Supreme Court had remanded back the matter, my lord was of the opinion that it has to go.
Oh, that matter. Something has happened.
Nothing has happened as yet. I think they are closing today and tomorrow they are closing and it will come up. Reopening will be July.
July 7th, man. July after
So
July.
after I have no objection. Let them.
Then counsel for the parties jointly submit.
In August first week.
Jointly submit that this matter should be adjourned, in the interest of justice to July, 8th of July. Next, August. We should July end.
July end.
August you are not saying it is reopening on
7th of July.
On 7th July.
7th July will not be proper. Therefore, in the last week of July.
Last week of July.
Last week of July.
That's right.
Your Lordship, the interim order passed earlier to continue.
Interim order shall continue in the meeting.
Obliged, Your Lordship.
Item number 60.
In like item 60, there are three matters. There are three matters, my lord. The last occasion, learned counsel for the other side has to time to file counter. And your lordship directed them to file counter. Despite that, they have not filed their counter. I have filed my note of submission. If your lordship permits, or if it will be on reopening, as your lordship please. Two particular statute and two amendment in two different state statute. Two amendment, I will take aid of two amendment in two different statutes. One OHRE Act, in the Religious Endowment Act and OE Act. The learned commission has not taken into consideration these two. Only pure question of law. If your lordship. Since other side is not there, they are the petitioner.
For the other side.
Mr. Paningray was appearing, all three petitions, and they are the petitioner before the trial court.
There is no representation on behalf of the opposite parties, contesting opposite parties. And counsel for the.
I'm for the petitioner. They are the opposite.
Counsel for the petitioners is present. So place this matter on Monday. Please inform him.
Yes, sir.
61.
61, this matter also remembers directed me to take instruction instead of any adjudication by lordships, they should go for acquisition of notification. I've just received an instruction from the Tahsildar. The collector has already mooted that proposal, and proposal because more than 8 acres of land. So it will take some time. We'll also collect after the summer vacation, so that in the meantime the government may come up with that notification.
Yes, the moment you come out with notification, the matter will end.
Yes, sir.
As requested on behalf of the estate, list this matter on second week of 27th June.
Item 62.
Item 62, I'm in VC, my lord. I am for the appellant.
So here the main question is, my name was selected, I was selected, my name was already published. And thereafter, my name was deleted. That is how I came before this honorable court, and the learned single judge has passed an order, and that impugned order particular paragraph is at page 13, my lord, 1-3. I'll just read out that particular paragraph, then I'll come to the merits of the case, my lord. Page 13, my lord, I'll just read. As it was found that the petitioner does not belong to Anganwadi center area, her candidature was not taken into account. And opposite party number 5, having secured highest mark and satisfied the eligibility criteria, was selected and engaged as Anganwadi worker of Patna Sai, that is the area, Anganwadi center under Tangi block in the district of Khordha. Needless to mention, the Anganwadi center area has been finalized by the standing committee. If the petitioner does not belong to the Anganwadi center area, her claim should not have been taken into consideration. Consequently, the appeal preferred by the petitioner challenging selection of opposite party number 5 cannot have been justification. In view of that is the order, my lord. Now, what I would like to state, my lord, the annexes were from 2 onwards.
No, but there is a judgment, Mr. Acharya, on this
Yes,
point. Whether
in fact,
candidate should be resident of Anganwadi area or the village.
Yeah, I'll come to that.
Anganwadi center area or the village.
Mr. Bhavani Shankar Tripathi was arguing that man.
Yes, I am
And
the first judgment in this regard, my lord, Sasmita Sahu.
yes.
So have you considered that decision? Have you seen that decision?
No, honestly not, my lord, but I'd just like to, I'll go through that. But in the meantime, I'll just rely upon the counter affidavit filed by the state, my lord. They have also relied upon the guidelines.
Yes,
Our
yes, I am saying that first judgment in this regard, that everything has been dealt in that judgment. You can find it from para 6, 7, 8. That the guidelines.
Mr. Acharya, better you go through these orders.
I'll do that, my lord.
Then make your submissions.
And another judgment of the Honorable Apex Court in this regard.
We in division bench.
Yes, your lordship
2024.
Yes, your lordship has given that. I could not find out that, but I have 2 judgments.
Anganwadi. Judgments are being filed by
Actually, what has happened, I'll definitely go through that judgment.
Yes.
But as far as the counter, I'll just take 1 second, my lord. As far as the counter is concerned, filed by the state, they have relied upon a guideline issued by the state, my lord. There it says it can be Anganwadi center or the village.
Or the villages that we have seen. But
Yes,
after considering that and other forms under the scheme,
right,
the division bench decision is there. So please go
through that. I'll definitely go.
Subsequent clarification, we have taken note of there.
Yes, my lord.
If in that area suitable candidates are not available, then they will go for next
Yes.
So just examine that.
adjacent areas.
Village.
I'll go through that, man. I'll do that.
Other circulars we have taken note.
That 2008 circular.
In response
That is the
to the
clarification.
submission advanced by learned senior counsel appearing on behalf of the appellant, learned AGA has relied on this court's orders dated so and so, order dated so and so. The DB you could not get. DB.
Division bench judgment I could not, but single judge order, my lord, that
Single judge will not.
and another by that Supreme Court judgment is there. I have given that a Supreme Court judgment that 2015 4 SCC page 30.
Order. List this matter on July 1st week. So as to enable learned senior counsel for the appellant to consider the aforesaid decisions and for making submissions in the present case.
Grateful.
My prayer is, my lord, I am appearing for opposite respondent 5. I have already filed a counter. That is not in record, I think, not in record.
All right, declare it.
It's there.
Is there?
Item 63.
This case, my lord, I pray that matter may kindly be taken up on Monday.
My lord, we have objection in this matter. We have filed a request of state. We got the copy. I'm handing over the vacation of state because it could not be brought on record. I have copies served on my learned senior.
No, but why didn't you file that in registry? Why should we take that?
It was because it was in the list. I did not file.
All right.
Because it is
The whole problem is yours will here and
No,
dispose it.
give him, file in the registry.
But I am appearing in this case for response number 1. This is an institution which is managed by a trust. It's a diploma engineering college. A matter was in a civil dispute. The matter was settled in a second appeal, first appeal, then second appeal, and it was upheld by the Supreme Court. The question was whether my client, respondent number 1, is the genuine trust managing trustee or trust or not. And during the pendency of the second appeal, this Honorable Court had directed the collector to be appointed as receiver in respect of that institutions. In fact, when the judgment was delivered, this Honorable Court, while dismissed the second appeal was filed by the other side, directed that the collector will hand over all the fixed deposit and so far the institution management institution is concerned to the trustee, to my client. In fact, in terms of that, the collector has handed over all the records. Now the whole question for consideration as decided by the Honorable Single Judge is that the fixed deposit which is kept in a fixed deposit, that the Honorable Single Judge had directed that since the original document is lost, because that is where it was lost, it is not known, the collector has filed an affidavit that I have not handed over. That is the affidavit pursuant to the order passed by the Honorable Single Judge. Then the question is, duplicate fixed deposit certificate has to be given. That is in terms of the RBI guidelines. That was the direction of the Honorable Single Judge. And that judgment has been challenged by the bank and an interim order has been passed. As a result of which, the day-to-day administration of the institution has been completely paralyzed. And at this juncture, some of the persons, those who are not no way connected with the trust or the management, villagers or something claiming to the public, they have filed another writ appeal challenging that order.
Where is the order of this court's interim order?
Annex 7, my.
No, interim order.
Interim order is at dated.
This is item number 65, no? 64.
The first case.
12/5/2023.
Interim order stage. So what I suggest if my learned friend is not ready today, then also fix any date at 2 o'clock so that matter can be disposed.
The status quo order is there.
Yes. As a result of which we are not in a position to that the order of the Honorable
We
Single
are
Judge.
unable to get the money which has been lying with the bank.
You are the bank.
Yes,
He is
I am
not
the
bank.
bank.
Huge crores of rupees is lying with the bank. I'm unable to.
What interest do you have?
No, I don't have any interest. What we have examined that you are not competent under law to represent the trust. Now, my learned senior has submitted before my lords that the Honorable Supreme Court or in the second appeal, it has been decided that his client is the managing trustee. No. His client, yes. Your lordship may kindly have a glance to that second appeal judgment.
We'll see later. But why are you seeking adjournment?
No, but I just need some time, my lord. Therefore, I take time. Otherwise, Monday it may be taken up.
Otherwise, we can.
Well, if that order, interim order is vacated, then we have nothing to say. Let them take adjournment as per the suite bill, because from.
No, my lord, interim order will be vacated.
That day, interim order.
When was the interim order passed?
First date when we appeared. I leave it to us.
The interim order was passed in their presence, my lord. Interim order was passed in presence of the cabinet.
My lord, we leave it to your lordships.
As jointly requested. This matter, not jointly, as requested on behalf of the appellant. This matter on July 1st week?
Yes.
They also fix up at 2
o'clock. 2 o'clock.
Yes.
The connected writ appeal also will come on.
That is there, yes, there.
All the matters.
Because there we are for the.
On 4th July. 4th
July.
July.
4th July, 2
PM.
o'clock.
Yes, my lord.
Balabno only say that I am filing that the interim
File that,
applications may be called for.
It will come.
Grateful.
I filed my appearance, remember?
Item 64. May I please, Your Lordship? Page 94, the impugn order at annexure 3 mile. Yes. Well, made page 95.
Yes.
So only short facts, my lord, if Your Lordship will go through this judgment, the only ground for rejection of his candidature is that he has not registered his name under the employment action, treating him as a BD candidate. For that reason, his candidature has been rejected. Only that is the ground. Plus,
So we have recently decided.
I did not, so I did not go.
That is, we come on a decision and employment exchange order.
That clause is there in the resolution.
On that ground, I did not read that judgment. I know, my lords.
No, that resolution.
It is not my view.
This clause.
We don't hold any personal view.
No, my lord. So this is the only ground we have rejected his
No,
candidature.
because that is contained in your resolution of
I am not
2014.
I am not disputing, so I have not read that judgment, but I cannot concede.
The appellate in the present appeal has put to challenge an order dated 14/10/2022 passed by a learned single judge of this court in WPC bracketed OAC number 1172 of 2016, whereby the learned single judge has
Page 100, my lord.
allowed the writ application filed by the respondent and has directed the selection authority to consider his case on the basis of merit. Stop. It appears from the materials on record, including the impugned order passed by the learned single judge, that the respondent's case was not considered for selection to the post of
assistant teacher.
Assistant teacher.
Contractual trained graduate teacher.
Huh?
Contractual trained graduate teacher.
Trained graduate teacher bracketed contract.
Contractual.
Trained graduate teacher bracketed contractual.
My lord.
Mainly on the ground that he was not registered with the employment exchange.
With BD qualification.
With BD qualification. He has
BD.
registered his name. Not
I have registered, but BD qualification with BD qualification.
With B.Ed qualification. So stop. It is not disputed that the respondent possessed B.Ed qualification.
Yes. And I also registered subsequently.
Subsequently as registered.
Registered.
So stop.
One single judge has held that the respondent's candidature was wrongly rejected on the ground of absence of registration with the employment exchange. Stop. Next. In view of, can you see that decision? Stop. The requirement of registration with the employment exchange as a condition precedent for consideration in a selection process has been,
In the case of State of Odisha versus Jayadratha Pradhan Paras, my lord's judgment.
has been gone into by this court in a recent order dated so and so.
State of Odisha versus Jayadratha Pradhan.
Kavi Pradhan versus State of Kavi Pradhan versus State of Odisha. No, it was not the case. Dusra.
Perhaps
Do you have?
Perhaps that State of Odisha versus, I can give that number if you.
In case of so and so.
I'll give that number. In course of that, I am.
Do not find any legal infirmity in the impugned judgment passed by the learned single judge. So this appeal has no merit and is accordingly dismissed.
May I submit one thing? Let's 60. May I fix up a date within which it is to be complied with. Single judge given 1 month time. That has been expired since long. In the meantime, 2 years gone.
Yeah. We have been informed that the order passed by the learned single judge has not been complied with.
This is state for which that has not been complied with.
Huh?
This was state in, this order was state for which.
No state.
No.
No.
11 steps. So this is what we are saying.
1/3/2023. 1/3/2023.
Okay. Till next date.
Yes,
Okay. The interim order stands vacated. Stop. Let the order passed by the learned single judge be complied with, be carried out within 1 month.
Okay.
From today.
That was never extended.
Well,
That was never extended.
I am seeing my file, I have on
No,
my
after,
files.
after that date,
No,
next day, that was up to next date.
Yes, ma'am, that
Next date, it was
No, yes,
never,
ma'am.
next date
But-
proceeding was there, but
yes, ma'am.
it was not extended. You have not prayed for extension. My lord is correct in
No,
looking at the orders.
No, because I have seen my file from my noting of my file as and on 17/11/2023, I will not.
You should have downloaded our copies from the orders.
No, 65.
Mr. Sandeep.
May I please, your lordship? Yesterday, your lordship told me to serve the extra copy to my learned friend. That amendment petition, my lord, IA 4560 of 24, which I filed yesterday, served him yesterday itself. But I want to just introduce, annex some new documents and make a partial modification in my prayer only, my lord. To cause the same, because after filing their counter, I come to the knowledge, the lease case they have decided that I want to bring to the original record, my lord. I pray that may be allowed so that I can file my consolidated petition by tomorrow or by Monday.
IA number 12550.
No. IA number 4563. This is the amendment petition. IA number 4563 of 2024.
The public interest litigation.
I have given my schedule of amendment also. I
Hmm?
want to amend my prayer accordingly.
Not usual. Yes,
The formal amendment also.
this application has been filed seeking amendment. The main writ application to the following effect. Paragraphs 1 and 2. Page 3 of IA number 464563.
Yes.
Prayer.
Reservation proceeding has already been over.
That is over. They have, without my knowledge, they have
Then cannot be de-reservation proceeding, they've got a right to appeal.
Mr. Samant.
My lord,
Mr. Samant.
I have got a plethora of decisions, my lord, where petition has a right to come to the.
Mr. Namtor.
Well.
Mr. Samantra, you see, he wants to add one prayer
No.
to issue writ of assurance.
Yes, no.
Read second prayer.
No, in fact, my
Paragraph
friend,
2.
my friend had given me a copy yesterday after the court was over, so I left it.
I just want to add it, to class it, that they may file their objection also.
The portion which he wants to add
Yeah.
may be nebulous or maybe genuine, but the prayer.
This, you file an objection, we will see.
Yes, then I will file an objection to it.
He prays to quash adding a prayer.
Yes.
In a PIL, he wants us to quash de-reservation case, orders passed in de-reservation case as well as lease case.
Lease case, no. After my counter was filed where I stated that all this has been done, I will file an formal objection to that.
My question, they have the right to file the objection even if I amend my petition, writ petition, my lord. So that the matter can be over at a time. If I amend my prayer accordingly,
We
they
will not
file the
allow
counter.
your amendment petition.
My lord.
We are not allowing your amendment petition now unless an objection is filed.
Your lordship may please.
4 weeks time is allowed for the state to 6 weeks to file objection to the interlocutory application which has been filed by the petitioner seeking amendment in the writ petition. Stop this matter on June ka second week.
Second
week of June. It's not second week of June, 24th, between 24th to 28th. May.
On 18th hour, it is reopening day. 18th is the reopening day, I think, of the vacation.
Before reopening.
27th June.
Okay.
Item 66. That especially the 60 years old, 80 years old lady deprived of getting family pension because of the some reason. The services of my husband were not verified during his lifetime. So accordingly, the Honorable Court directed the opposite parties to verify and reconstruct the service record within a time frame. But when it was not carried out, again I filed the IA, page 28, my lord. The very specific order dated 1/11/2021. The prayer in this IA is there should be a specific time limit indicated for compliance with the direction.
No, where is the order passed by this?
My lord, yes, page 9.
Page 9.
Annexure 1, page 9 of the contempt.
Yes.
My lord. Counsel for the petitioner states that petitioner has received information on 20th February 2020 from the office of the Senior Divisional Finance Manager, East Coast Railway, Khurda, that instructions have been issued to the Senior Divisional Personnel Officer, East Coast Railway, to reconstruct the service record of the petitioner's late husband. He accordingly states that the petitioner will follow up the matter for grant of family pension with the East Coast Railway, reserving the petitioner's liberty to seek appropriate remedy. If there is a delay in her getting the family pension, the writ petition is disposed of. Again, page 28, page 28. So I supplied the documents, page 28. In the IA, 28 of this content petition. The prayer in this IA is that there should be a specific time limit indicated for compliance with the direction issued by this court on 7th April 2021. In that view of the matter, a direction is issued to the General Manager, East Coast Railway, Bhubaneswar, OP number 2, to complete the steps indicated in the order dated 17th April 2021, not later than 1st September 2021. So thereafter, my lord, I supplied the documents, my husband's appointment order. Yes.
My lord, as per my instruction, my lord, it is the second contempt. My lord. The first contempt was dropped with a direction to comply the amendment made in para 10 of the contempt petition, compliance of the contempt petition. And after that, my learned senior has again filed this contempt petition. My lord, the petitioner has filed a representation, and that has been disposed of by a speaking order. My lord, that is
When?
No, my lord, the speaking.
Let him say.
R by 1. R by 1.
My lord. That is on 1st December 2023, man.
1st December?
2023. That is under Annexure R by 3 to the show cause reply, man.
They have passed an order.
No, my lord, this, my lord, the order, this Honorable Court directed the General Manager, present contemptor, who is the appropriate authority, because in case of Group D employees, my lord, the opponent is a competent authority, but my husband was working senior clerk. So where under the railway establishment rule, General Manager was the competent authority to condone the delay or to regularize the break in service or to regarding verification of service record. Accordingly, my lord, the page, the interim order, in the interim order, it was clarified, page 28. So the General Manager, my lord, the present contemptor has not taken any steps. He is only, my lord, the submit, my lord, giving instruction to the Divisional Railway Manager or the subordinate staff of the Khurda East Coast Railway. You take steps, but the direction was given to the contemptor, present contemptor, who is the appropriate authority under Railway Establishment Code. He can verify the record. So they cannot, they are competent to work out the problems of the Group D. But presently, the my lord, the
Has the decision been taken?
My lord, no, presently GM is to take this
Counsel,
step.
whether
Yes,
General
my
Manager has taken this
my
decision?
prayer. So GM is very benevolent.
Whether the General Manager has taken decision?
Yes, my
My lord, that instruction I don't have it.
No, R1 has been issued by whom?
My lord, that has been issued by the Chief Personal Officer.
What does it read? Whether that has been communicated based on any decision by the General Manager or someone else?
Well, I will take instruction. Let it come on Tuesday morning.
Tuesday.
Ma'am.
And otherwise, the contempt is made out.
I'll take instruction.
As requested on behalf of the contemptor. Let's this matter on Tuesday.
61. Sorry, 67. Item 67.
67, my lord, on behalf of Mr. Esk.
Credible documents for reconstruction or service requirement. Your representation.
67 वाला on behalf of Mr. SK Das man I'll take after vacation mail.
As requested after.
Item 68.
July, madam.
May I please notes.
Adjournment because the contracting council.
May I please notes, I am for the appellant with the Mallard's kind permission and through VC Mallard. I am for the appellants.
Yes, please.
Yes. Mallard, the impugned order dated 1st March 2024 of Mallard of the Honorable Single Judge is under annexure 8 in WPC number 12356 of 2018 is under challenge.
Where is that?
Mallard, that is at page 82, Mallard. Mallard, this writ application was a final. Learned counsel for the appeal, opposite party number 4 and 5 further submits that before taking the decision, the opposite not only resolved for fill up the post of banking assistant to the extent of 30% earmarked for the employees working in different societies affiliated to the bank, but also sought necessary permission from the opposite party number 2 to relax the upper age limit by letter dated 7/4/2016 as one-time measure. Since no decision had communicated on such request of the opposite party bank, the bank on the bona fide impression that the proposal submitted by letter dated 7/4/2016 has been accepted by the opposite party number 2. Hence took the decision dated 18/1/2018 to appoint the present petitioners and 9 others as banking assistants as against the aforesaid 30% earmarked for the employees of the working in different societies. He further contended that in view of the inquiry made by the opposite party number 2 and 3, subsequent to the appointment of the petitioners as banking assistants, the salary of the petitioners were not released with effect from March 2018. But as reflected in Annexure F/5, the petitioners have been permitted to take their pay from the concerned society in the reverted post. Since all the petitioners have been reverted to their original post as per the order dated 9/7/2018, next, then para
नहीं noting those. Mr. Kampasari.
Personal appearance was directed? No.
No.
We are adjourning it. There is a memo available on. As requested on behalf of respondent number 4, list this matter on provocation.
Undelivered notice one achi. Neither ready nor undelivered notice. You are for respondent numbers?
4 and 5.
4 and
What
5.
about others?
That is my employer.
Many other respondents are.
Those respondents number 6 to 13, they raised a dispute challenging our appointment in the court of the respondent number 2, which was pending.
7 to 13 कौन लिखता है?
Those are the respondents there.
7 to 13 sir.
All right.
6 is not there.
We will see.
6 has not come forward.
Can I fix up a date?
Yes.
4 and 5 sir.
Yes, Mr.
May I pray for fixing a date?
Date you will get 4th of July.
Item 69.
May I please, so let's see.
I have also filed the intervention in this application supporting the petitioner.
I also
do
file
that.
an intervention application supporting the petition.
It doesn't happen.
Sometimes, my lord, either
No,
way,
no, never.
either I will support because so far the intervention concerned, but I have a very limited chance in the lordship to
Intervention
assist.
applications are filed only to oppose.
My lord, either
The-
supporting or opposing,
No, no, it is not the law.
either supporting or not. That let it come tomorrow. I will
Where is the
substantiate that.
question? There is see CPC.
No, because the role of an intervention is very limited. You will only assist your lordship. He may not even file an application or counter in any form.
No, no, role
So I
of-
want to aid your
Sorry,
lordship,
sorry.
assist your lordship.
Sorry. Let them argue. Sorry.
Well, challenging annexure 1, you let's say, taking over the school.
The state has not yet filed their counter. The here state wants to take over a school, my lords, which is
Already
managed
taken
by
up.
the board of secondary.
Already taken up.
Notification has already made. That is challenge in a public interest litigation. Lord, so I will file a detailed so called affidavit to the lords.
So he is challenging taking over under public interest litigation.
Yes.
My lords. Why I'm saying so, my lord? The Board of School is established under a special act called Board of Secondary Education Act 1953. My lord, nowhere in that act the clause or law of taking over is there. The entire act does not speak, my lord, about the taking over of a school. It is established, my lord, under section 11K of the Secondary Education Act 1953. The taking over of school, my lord, is investigated under Education Act 1969, where a resolution is being passed by certain boards, those who have established the school to take over, the state government can take over that school. Here is a school, my lord, which is not established under Odisha Education Act 1969, my lords. It is an act established under Odisha Secondary Education Act, and my humble submission is nowhere in the entire act the question of, my lord, taking over is arises. Moreover, the resolution itself, my lord, contradicts the acts. They are taking recourse of section 14B of the act in the resolution, as well as section 34 of the act, my
What is
lord.
the public interest?
My lord, I am an ex-student of that school.
Huh?
I am
No. What is the public interest?
Mikkel,
We are considering a public interest litigation.
my lords.
So how is the action taken by the state government
My lords.
is contrary to public interest?
My lord, my humble submission is, my lord, I am an ex-student of that school, and it is a model school of the entire state, established due to the Modular Commission, established under 1959, my lords. There a decision was taken by the central government to establish.
We are again putting this question. How is the action of the state against public interest? Like you can say that because of taking over, the standard of education will deteriorate, or because some serious prejudice is going to be caused to. This is not public interest, means you will have to demonstrate. Otherwise, someone aggrieved may challenge that decision.
My lord,
You cannot.
My lord, with due respect, my lord, state is acting against the statute.
They may, but you cannot challenge.
My lord, if that will be the position, then I have.
That is not public interest.
My lord,
It's a misuse of the process. Everything cannot be taken in public interest. Every violation of law cannot be taken in public interest because it is contrary to law. The public interest should be involved. This is not the way.
My lords,
Public interest litigations are taken.
then lordship will, I pray my lords to adjourn some other day. I will satisfy my lord after
Yeah.
vacation.
When
After vacation, my lord.
we are of the petitioner in the present writ application in the nature of public interest litigation has questioned the legality of the decision taken by the government of Odisha to take over Secondary Board High School Cuttack.
Yes.
Secondary Board High School Cuttack. It is the petitioner's case that the said decision of the government is in violation of statutory provisions.
My lords.
Stop. Next. We are of the prima facie view that the petitioner has not been able to establish that because of the said decision, public interest is adversely affected for this court to entertain this writ petition in the nature of public interest litigation. So stop. Next, learned counsel for the petitioner seeks adjournment to respond to make his further submissions. So stop. Place this matter on. When do you want?
Just after
Whatever
vacation.
time.
Just after vacation, any day.
Whenever. 4th July.
After reopening, my lord.
Yes, yes.
Item 70.
4th of July.
Item number 70.
Item number 70, contempt or filed show cause, madam.
Were complied with.
Are not complied.
Where is the order?
Order dated 15/9/2023, madam. Page 7, Annex 1.
Where is the, what is the order? Yes. What is the order? Which order has not been implemented?
Order dated 15/9/2023.
So your dismissal has not been
Page 10.
properly complied with.
My lord, kindly see page 10. Page 10, para 8, my lord. The contention raised by the learned counsel appearing for the management petitioner that the workman opposite party number 1 was continuing as a contingent menial and as such he
Issue
is not
notice.
entitled for.
You are workman.
I am workman.
It has been complied with.
Not complied.
Not complaint.
So notice.
No, Lordship, sir, please to issue notice already, my lord.
Already issue notice.
On 4th of April.
Hold on.
Mr. Prabhakar Behra is to appear.
Yes, sir.
Odisha State Transport.
Yes,
Who is
Odisha
that?
TC, Mr. Tripathi also now appears, my lord, sir.
Ask him to be here. Please inform him. Otherwise, we will have to issue warrant of arrest. Because service of notice is already there.
Yes, ma'am.
So I will intimate one of the councils to not look into the matter.
So we don't have any other choice.
Mr. Prabhakar.
Yes.